Blessings falling on me. I got weapons, need no army. That like Tetris, you don't know me. That my fatty, you don't know me. Okay, hey now, it's a new kid on the playground. So many bags on me, you would've thought I was spray ground. Now they know I don't play around. I can hear what you're saying now. I just doubled up my flight miles. Coast to coast, no they ain't in town. I get rich, watch, then I get a sick watch. Watch me hit the top, I might make a TikTok. Left hand, right hand. Catch the latest trend, I might double up my net worth. I've been going up now, see the top going down. If you didn't know now, I know you know now. That's cause he could go on top, you not really top. You keep saying top, well I guess you let the top down. I've been going up now, see the top going down. If you didn't know now, I know you know now. That's cause he could go on top, you not really top. You keep saying top, well I guess you let the top down. Made a wish, now I'm here now. It's for real now. I got everything I wanted and it's jumping like for real now. Out the mud, just another state boy now. I'm living like for real now. I get fly, you fly, crushing on crush down, that ain't fly.
Good morning, everyone. We are back for another live stream, day 2 of the motion hearing. You have to excuse my voice. I am not feeling well this morning. I have a sore throat and it's killing me right now. But we are going to still take care of what we need to take care of. Thank you, Maggie. Thank you, Maggie, so much. She said just stopping by to say have a great stream. Thank you. Drea said hiya. She said going to be missing most of the day, but popping in to show some love until I have to go. I appreciate that, Drea. Thank you so much. Thank you so much for being a part of the stream. Until you have to go. I understand. I totally understand. I totally get it. But again, yeah, I'm having a bit of a sore throat. I have a warm beverage right now to take care of it. And so, yeah, we're going to go ahead and take care of what we need to take care of. What up, though, Felicia Fee? What up, though? How you doing? How you doing? Excuse my voice. Yesterday was very interesting. We see that the bonds were denied yesterday, which is kind of crazy. But the bonds were denied. Excuse me. And she laughed at me. Don't be laughing at me, man. Bonds were denied yesterday in the case. We did have a little bit of a squabble of Lawyer Love and Lawyer Steele. The state is still trying to get the defense to reciprocate evidence when they don't have to. Okay, basically, that's what that was yesterday. And so he cited a lot of cases, I think about 4 or 5 cases. And so, but you don't have to, the burden of proof is on the prosecution. The burden of proof is on the court. You do not have to render burden of proof of anything when it comes to evidence, when it comes to the defense, until you're ready to do so, you know? And so right now, case in chief is the problem. All right. So we are back. We are here. Yes, I have right here.
I trust you had a productive evening last night, and I understand that the parties have proposal with regard to at least a portion of Mr. Copeland's testimony. Sorry, I didn't have this turned on. So what I said was I trust everybody had a productive evening, and I understand that there is a proposal with regard to at least a portion of Mr. Copeland's testimony. So I'll hear what that might be.
Good morning, Your Honor.
Morning.
Simone Hilton for the state of Georgia. Last evening, myself and Mr. Shard had a brief conversation regarding the testimony of Mr. Copeland.
Yes.
I believe the defense counsel have to speak among themselves in order to determine what portions of Mr. Copeland's testimony they are asking to be kept. And so we believe that we need a copy of the transcript.
Okay.
So that they can have that conversation. Once defense counsel has that conversation, then they'll speak with the state about their proposals and we can move forward from there, Your Honor.
All right, so I don't believe that I think we have the 7th available. I don't know that we have the 11th and 12th yet, but I think we've reached out this morning to Ms. Weaver, the court reporter, and I know she has some other people working with her as well. So we'll endeavor to get that to y'all as soon as possible. And she's been pretty fast with the turnaround. So we may even have parts of it by the end of the day. So that seems like a reasonable approach. And then I would think that the next thing we can do, to the extent y'all feel like you want to revisit evidentiary issues with regard to any of the videos, or I don't think you had gotten to the jail calls yet anyway, but with regard to the videos, we can probably do that now.
I appreciate you all.
Don't think? Otherwise, give me something else we can do this morning.
Yes, we can do that. If you can, we just need to get that material very quickly to the office, to the courtroom.
All right. Send somebody to go do that, please.
What's up with the green and the purple and what's going on with all this?
Has anybody thought through yet, and maybe we'll have ready soon any kind of potential instructions for what we're going to be telling the jury about either Mr. Copeland's testimony, well, I guess generally Mr. Copeland's testimony, and then I'll entertain what we're going to, I am going to say about the fact that here I am instead of Judge Glanville. But I mean, for that, I'm thinking essentially just, I don't know, some matter has required a substitution of judges, and that's about it. I don't plan to tell them really much more than that. They don't need to know why.
Your Honor, given the conversation Ms. Hilton had with the defense last night, in that some of them may be seeking to have some portions of it kept, depending on the court's decisions regarding our respective positions, I don't think we can craft at this point. For instance, if we decided, everybody said, let's just keep it, then we would just keep it, understanding that's likely not going to be the case until we know the respective positions and the court's ruling on that. I don't think we could endeavor to craft it.
Yeah, that may be true. Okay. Yes, sir.
Good morning, Your Honor.
Good morning.
Good morning to everyone. Your Honor, I would, and Mr. Adams can opt out of this if he believes it, but I'm objecting to anything except the unvarnished truth about Judge Glanville. I would like the court to tell the jurors the truth, that he has been found to be disqualified and removed from this case for his conduct. And that's my instruction that I worked on. That's what I'd like you to do.
All right, well, I'll consider everything once I've got everybody's proposed instruction, to the extent anybody wants to provide one for me to think about.
Thank you.
And Your Honor, I believe that the statute, if I'm not mistaken, regarding recusal specifically, speaks to the fact that that is not to be made a portion of the case in chief, of the main case. I will get the exact language that I'm speaking of.
All right, great. Thank you. I appreciate that. Okay. Anything else?
Yes, Your Honor. We also briefly discussed yesterday the exhibit list, talking about how we can resolve working through the exhibit list. And my understanding from Mr. Shard, I'm not sure if Mr. Kokomo was finished yet, but Mr. Kokomo, who's his legal assistant, and another legal assistant, we're actually working through the same thing that our legal assistant is working through. And our hope is, hopefully the court will be okay with this. By next Wednesday, our legal assistant would have gone through every video to assure we have all of the correct exhibits. But it's taking time because she's literally watching every single time we're in court.
I'm not okay with waiting until next Wednesday. I mean, I'm hoping, and it may be a false hope, but I'm hoping that we'll have a jury back with us by next Wednesday. So that needs to accelerate.
Okay, we will work on accelerating that list to get it to the court. But I believe that they're working on it as well.
Well, they need to accelerate as well.
He
If
has
their
had
thought was
more than
next
enough
Wednesday.
time. You've had 2 years to do this.
I'm thinking this Friday, okay, which is the day after tomorrow.
My voice is good enough, dude.
All right, with regard to, and you're talking about the videos of his testimony, right? Or are you talking about?
No, I'm sorry, I should have been clear. To confirm what exhibits have been admitted and not admitted. That's what we've been working on. No, that's
the giant list of
list of exhibits.
Yeah, that's fine. That can be next Wednesday. That's not that urgent. As long as we've got that correct by the end of the trial, that's all that really matters. I thought you meant Mr. Copeland's testimony.
No.
Okay,
Your Honor.
all right. My misunderstanding then. Okay. All right. So with regard to the video interviews of Mr. Copeland, I suspect there are parts of those that the state knows they intend to be using or suspects very strongly they probably need to be using. So can we either come to some form of an agreement about evidentiary rulings that were already made, and or let's figure out what I need to do again?
Yes, Your Honor. I believe after we had the initial arguments regarding some of the redactions, some of the redactions we did concede on. So once I get that list, I can let the
Well, I've already seen those with regard to a couple of things, but I haven't gone through. I mean, I was looking at, for the transcripts I had, the arguments that y'all had already presented, and I saw that there were maybe like a couple, I don't know which, I can't remember right offhand which dates I've already looked at, but there didn't seem to be that many that y'all just conceded. Seemed like y'all argued and needed a ruling for most things, but what I'm saying is, having argued it once and having gotten a ruling from a judge who knows what he's doing, whether y'all like him right now or not, do I need to re-listen to each argument and make my own determination, or can y'all agree that, hey, you know, the law, regardless of us arguing our various sides, the law probably is this, and we're okay with that ruling?
We believe out of them, we believe, and I'm sorry, Your Honor.
Go ahead.
Out of them, we believe that there might only be two that we think may need to be re-argued.
Okay.
I just want to, we don't think there's many, at least from the state's perspective.
All right, that's good.
Your Honor, I'm speaking for myself. Yesterday, we received a transcript that was a transcript of an ex parte meeting that occurred on Friday.
Right, this is the
Before
one.
the Monday.
Sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had said, oh, yeah, we had, and in court on the record, but ex parte discussion that led to the Monday, June 10th ex parte. So that's what you're talking about?
Let me be more artful, yes.
Okay.
We were made aware, leading to the recusal of Judge Glanville, that there was an ex parte meeting that occurred on June 10th, Monday, June 10th. We were not told by the state, we're not told by the judge that had occurred. We found out about it, luckily, and by happenstance. We then demanded a transcript. We complained about said ex parte, inappropriate ex parte meeting. at no point, when the court finally acknowledged that there was an ex parte meeting that occurred on Monday, June 10th, at no point did the court or the state at that point acknowledge, oh, by the way, there was another ex parte meeting that occurred on June 7th. We sat there after finding out about one ex parte meeting and having to drag the truth out. We sat there and the state and their co-conspirator, the trial court, were silent about the first ex parte meeting that happened on June 7th. What happened in that meeting on June 7th? The state went in and disparaged defense counsel. The state, with no one else there, trashed a fellow member of the bar, Mr. Melnick, trashed another fellow member of the bar, Caleb Bumpus, presumed the guilt of all these individuals, including my client, Shannon Stillwell, and all but accused myself and Mr. Steele of being co-conspirators in this YSL enterprise. And the judge agreed. And the judge said in this ex parte meeting, yes, I've observed these things. The judge presumed the guilt of all the defendants. The judge presumed the guilt of myself and co-counsel, Mr. Steele.
What?
And all this, people have been saying to me throughout this whole trial, why does Judge Glanville have it out for you? And it never made sense. And I don't assume bad motives of anyone. Why did Judge Glanville, when you did nothing wrong, try to throw you in jail? Accuse you of cussing him out in open court when you didn't do anything? Why does he always tell you, yell at you, tell you to sit down and be quiet? Why does he cut you off at every opportunity? Why did he try to throw Brian Steele in jail for 20 days for doing what was right? And I didn't have an answer. And then yesterday I received, and I appreciate that, Judge. I appreciate someone finally being open about what's going on here. And I received a transcript. And in that transcript, the trial judge, who's not only assuming the guilt of my client, but is assuming the guilt of me and my friend, Mr. Steele.
Wow,
this is gross.
dude.
This is disgusting. But it's all starting to make sense. It clicked when I read that transcript last night. This is not okay. Nothing about this is okay. These gentlemen have a right to a fair and impartial judge. And I appreciate the fact that you are going to be a fair and impartial judge. But the reality, Judge, is that they don't have a right to a fair and impartial judge starting on witness 76 of a trial after 9 months or whatever it is. They have the right to a fair and impartial judge from the beginning.
Yo,
and this
Shard
is absolutely gross and disgusting.
This is crazy. This is crazy.
And the bottom line is there's a lot more discussions that need to be had about this. But the bottom line is, if you ask me, do we need to revisit the rulings of the judge who sits in chambers secretly and talks to the other side and says, yes, I've been observing this. I've been observing this about what's going on in the trial. The judge that says, not only I'm going to meet with you on Friday and on Monday, but if we need to talk during the weekend, yeah, we can do that. The judge that suggests handing Mr. Copeland a list of questions. Do we need to revisit those rulings? Absolutely, we need to revisit those rulings. We need to revisit everything. This is broken, and it's not okay.
That's facts.
It's not okay.
Wow.
It's offensive. And it's not
already
your fault,
hot,
Judge.
y'all.
You didn't do this. I'm not trying to raise my voice at you. I'm heated right now.
I can tell.
My steam's been coming off my bald head all night.
Shout out to the bald
Nothing
head,
about this
dog.
is okay. Yes, we need to revisit everything. That's my stance.
Okay, thank you. And I think that I understand you being upset, and I understand why you and probably some of your fellow defense counsel on this side of the room are upset. I do not think that everything you said is a fair characterization of what that June 7th transcript reflects.
What?
But
Man.
once we have the official copy, that'll be made a part of the record, and that will show what actually happened, what actually was said. As to any kind of legal error that may have been made with regard to rulings prior to Mr. Copeland's testimony, assuming this case goes forward and assuming there is any kind of conviction, I then assumed that there will be a motion for new trial phase, which at that point I can appropriately revisit things, and then potentially an appeal, at which point those things can be raised. I am considering and reading what y'all gave me yesterday to make a ruling on the substantive matters of that ex parte, and I can consider the June 7th ex parte as well, because I suspect y'all asked me to do that. And if I determine that that is such, that there was coercion that is unconstitutional or structural error, then I will grant a mistrial. If not, then the case will move forward and we can consider again all of the evidentiary rulings with regard to the videos and audios that might be used with Mr. Copeland, because that's the witness that we are on the stand with right now. I would, and I know this is hard to do, but I would like for everybody to try to take some deep breaths and move forward professionally. A lot of what y'all are talking about doesn't make it any easier, but it happened a month ago. I know tempers flared all around, but we need to move forward with this in whatever way it's going to move forward in a calm and professional manner, okay? So then with regard to what we need to do evidentially, I guess I will need to hear from the state as to what y'all think it's very likely for you to be using while you're examining Mr. Copeland, and then I will entertain evidentiary objections for responses, and we'll consider what's coming in.
Thank you, Your Honor. And we're getting that ready as we speak to present to the court. And I'd also like to thank Your Honor for the reminder regarding professionalism. I was going to ask that the court require that we all adhere to that. Being called co-conspirators is not something that I would expect to have heard, no more than I would expect to level an assertion that Mr. Sharp is a defendant. So I'd ask that that all sides be required to adhere to the court's admonition.
Well, again, the transcript will reflect what was actually said in there, and there are some allegations that if I were an attorney and it were leveled against me, I mean, I am an attorney, but you know what I mean, practicing in a case, I would be a little hot under the collar as well. Y'all had potentially legitimate concerns. I don't honestly at this point right now need to rehash all of that. But the reminder is to everybody, okay? And I mean, I've said it, so let's act accordingly.
Ron,
Yes, sir.
if I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because, again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Sharp, am extremely upset having read that transcript, myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
Well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him. And now I have been made to look like an idiot.
Yes.
So
well,
I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. Yeah, if y'all feel like you need to get it off your chest, come on. Now's the time.
I got one more thing to say there. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor.
I mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right. Well, you know.
This is new discovery,
well, I
man.
don't know. Obviously, I don't know what to say right now either.
You can't say
but
anything.
I think that, well, again, I understand frustration. You know, let's be careful about disparaging a respected judge. I do think that he has, and I haven't looked at every transcript yet because they haven't all been produced yet, but I don't think you're wrong that he has been trying his best and doing his best. And, you know, we all as lawyers know that everybody talks about lawyers trying to herd cats, and that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think sometimes it is possible to sort of get so enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being amenable to hear what the other side is saying, and hell, that's true in our whole society right now. Should have said hell, but y'all, I mean, all right.
Those were not my words. Those were Chief Judge Glanville's words. If this was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the two transcripts and I will make a ruling. And again, I don't think that the characterizations are exactly accurate, but I'll consider it all. I don't think that the characterizations, all right. Anybody else, or can we move on to evidence?
Man, I don't like her, man.
Mr. Steele.
So there are 16, and good morning again.
Good morning.
Good morning, Madam Court Reporter. Ms. Winfrey, there are 16 hours approximately of the video audio you're talking about.
Okay.
And yes, we were going through to dissect objections, but I, and among others, really had an overall objection because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put in at all. So I understand what you're doing. You know, okay. We're going with you, but I just want you to know that we're not conceding that the way it came out, and obviously it's going to be redone after, I believe. I heard what you said yesterday. I agree, but that's the law. I don't believe that it should come in at all. So before you tell us later, hey, why'd you make me do that?
No, I understand. And I think that Mr. Shard had actually put that particular objection in writing in one of your filings anyway, essentially that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but
I had one thing. Just another layer of that. Oh, I'm sorry.
Go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements, that our stance is that those were not in furtherance of conspiracy either. So there's like two layers of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement?
The state
can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on actually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
Yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that, and it was a flat out lie, and I'm paraphrasing, but that is what they're talking about, correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Shard, Mr. Steele? Yeah, so that's what I would like for y'all to address.
Your Honor, we believe based on two positions, OCGA 24-6-621, which be impeachment by contradiction, as well as a prior inconsistent statement in both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement in to come in.
Okay, and 24, the 24-6-621 is the
Impeachment.
by contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes, Your Honor.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
Your Honor, if you can give us a moment, just because
Okay.
we need to.
I mean, y'all, when
Right.
I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to get me the law, go ahead.
That's what she said yesterday. If we win it, if they win it, then let's keep on rolling. Yeah, now we keep on rolling. We find out there's another ex parte meeting that you were trashing the defense on.
We can also do this portion after lunch and do something else right now, because I don't know that we all need to sit in court and do our research. What else could we do that's productive?
You can actually motion the mid-trial.
Yes.
I would like to make records. The Honorable Attorney John Melnick is under subpoena. He's in your courthouse, to my knowledge, or to my belief.
Okay.
I believe. If your court thinks that's good use of time, he is going to, I believe, take to task the statements of Lawyer Love.
All right. Well, tell me why that matters, because what may have been the actual truth and what Miss Love and or Miss Hilton perceived and therefore caused them to want to speak to the court ex parte or not, don't really have to be the same thing. And I don't know that it matters whether what they thought was true was actually true.
So objectively, he will go through the emails for the court that were misrepresented by Lawyer Love. I will then, I'm making a record, God forbid there's an appeal as well as for your consideration in this case going forward about calling Judge Glanville as a witness, that he spoke with Lawyer Love. She knew that he represented Mr. Copeland. Lawyer Love said that she did not know that he had denied representing him, Mr. Copeland.
That Mr. Copeland had denied that Mr. Melnick represented him.
No, Lawyer Love stated that John Melnick had previously denied representing Mr. Copeland. To Judge Glanville. And that goes to the heart of why is there a ex parte meeting in the first place? Because I don't know why there was, but Judge Krause I've objected to it. And I know you said maybe not, it's dicta, and I agree with that. It did not go to the holding or the ruling. And she didn't make long statements of fact or findings of fact. So I appreciate you saying, I don't know if these are findings of fact, but maybe just surplusage. But if that meeting is the way Judge Krause found, and there is a honorable Superior Court judge who made that ruling that's cemented in our case, that, I forget the line, but something like maybe it should have been done in open court, but the substance may have been proper, something to that effect. If it was done in open court, I would have been able to be there to question Mr. Copeland. I would have been able to be, because the Judge Glanville said, do you have questions for your lawyer, the state, or me? If I was there, I assume he would have said, or Mr. Steele. And then people were asking him questions. They were discussing his testimony. Those are things that we had a material right to be present for. So the point I'm trying to make.
Okay, well, I'm going to make a substantive ruling with regard to that, and I don't know how Mr. Melnick is going to add to that. I mean, it is clear to me from reading that June 7th transcript that the questions they had about whether Mr. Melnick represented Mr. Copeland. Is he literally counsel for Mr. Copeland right now? I mean, they knew he was that because Ms. Hilton said when Mr. Copeland asked to talk to Ms. Hilton outside of the courtroom, and they were about to talk, Mr. Melnick either was there or appeared, and Ms. Hilton said, "Oh, you seem to want to talk to him, so I will let y'all talk privately," which if she didn't think Mr. Melnick were representing Mr. Copeland, wouldn't have done. I mean, there would have been no reason for her to do that. I think that it is clear in context that what they meant by we've got questions about whether he's representing Mr. Copeland is, and they said it, we have questions about whether he is representing Mr. Copeland's best interests, which as a lawyer, you are always supposed to do for your client. So I don't think they meant literally, has he entered an appearance for Mr. Copeland, or has he represented to us and to the outside world that he is counsel for Mr. Copeland? It was,
he's been counsel for Mr.
is
Copeland
he really
for 2
acting
years.
in the best interest of Mr. Copeland? That's what they said they wanted to research and then meet with, or potentially meet with Judge Glanville about.
On the 10th, Lawyer Love said John Melnick, the Honorable John Melnick, stated that he was not representing Mr. Copeland. And Mr. Melnick said that is just a flat out misrepresentation of conversation.
Okay, well.
So I just want to get the record straight because Georgia law, and I gave you these cases in a footnote. Georgia law right now, and I know I'm very familiar with this Honorable Court's very in-depth knowledge of the law. So right now, it's if the court finds, this court finds, or an appellate court, that Mr. Williams et al. Had a right to be present, that's at a critical stage of proceeding, it's over. The case, no one looks at prejudice. But the two cases that came out in April, one of them may have been in January, but I cited them in the footnote of my motion to just educate the court.
Well, if it's there,
I could give it to him, but yes, it's
that's
there.
fine, I'll jot it down.
But the Georgia courts are saying that is the law now, but we are interested in whether that is wrong.
Okay.
And we need to show prejudice.
Okay. With regard to,
Like federal.
give me the cases in what?
Step back.
Okay.
But so I want to make a record of showing it was prejudicial because there were knowing
Me too.
misrepresentations to even have a auspices of a meeting with the judge.
Okay, well.
And I'm not agreeing.
I'm not sure if I follow you though, with regard to, I need to establish that Mr. Melnick was in fact counsel for Mr. Copeland, because even in the June 10th ex parte meeting, Ms. Bumpus was there as stand-in counsel for Mr. Melnick because apparently Mr. Melnick had said he had a pre-scheduled vacation or something like that, which everybody knew about on Friday or before Friday. And they were saying, you know, how can he actually be representing him, i.e. the best interest, if he's off on vacation when this critically important thing for Mr. Copeland is going on. But here's his standing counsel, Ms. Bumpus. So they understood that technically, at least, Mr. Melnick was representing Mr. Copeland. So, I mean, that's, I can take judicial notice of that to the extent I need to.
I'm inarticulate then, because Mr. Melnick, I believe, is going to have testimony before your court for you to judge credibility.
Okay.
That what was said out of the mouth of the two prosecutors, Hilton and Love, are not true. There's no emails to back up what Love says. Ms. Hilton, there is not this Mr. Copeland, I need to speak with the DA. Those things have been unrebutted. They're just being said. And my point is, without that, then why are you questioning another lawyer's ethical duties? What gives you the right to say that to the judge? And then the courts need to know that's not true.
All right. Just like I said to the state essentially yesterday with regard to their motion that suggested that defense attorneys were violating bar rules in the way that they talk to the press. I am going to suggest to the defense that if the state is violating bar rule, or attorneys for the state are violating bar rules in the way that they talk about defense attorneys or in representations that they make to the court, that too is something that they may have to deal with the state bar.
I understand, but I'm dealing with, my concern is Mr. Williams. So I'd like you to make findings, because I think that they go to the heart of, you're entitled to ethical prosecutors. We demand that. Ethical lawyers, ethical prosecutors, and a fair tribunal. That's constitutional, as a fair tribunal. That did not happen here in my advocacy, in my viewpoint, the way I understand what happened. I wasn't there. So I can't talk about, I wasn't in the outside the courtroom when this supposed Mr. Copeland wants to talk with Ms. Hilton. I don't know. All I know is what, we do. We come in after the fact and we investigate. But I'd like to spread that on the minutes. So I raised that. I don't know, Mr. Melnick's day-to-day or.
I don't know that.
But I'd like to call him.
I understand. And I don't know that that is ultimately relevant to the determinations I have to make, because again, whether what the prosecutors represented to Judge Glanville was true or not, maybe an issue for another type of tribunal. But in terms of whether it was then appropriate for Judge Glanville to okay the June 10th meeting to further flesh that out is what I need to figure out, right? So it doesn't really matter whether what they said was true for that purpose. It is, they told Judge Glanville what they told Judge Glanville. Was it reasonable at that point for Judge Glanville to entertain the ex parte on Monday, the 10th? Okay. So let me make that determination.
I'd like to call him if you change your ruling. Both of them, Judge Glanville.
You can proffer what he would testify to.
Then I need to, because he didn't see this new transcript, so I need to, he being Mr. Melnick.
Well, what's in the transcript shouldn't influence what's true. So
I would think, no, it doesn't. I would think that he can then say, or tell me and I'll tell you, and then you can hear from him if you want, that did not happen or this. I want to get it right.
All right. So you haven't talked to him yet about what? All right. Well, obviously I'll give you a chance to talk to him before you make a proffer, because you need the proffer to be accurate.
Okay.
All right. So that's not something we can do right now either.
Okay. Thank you.
All right. So what can we do? And if there's nothing, then I'll just go back in chambers and I'll read all my cases that y'all gave me yesterday, and I'll make some rulings so I can still be productive and y'all can be productive out here. You want to break for an hour and a half? Okay.
Thank you.
All right. Let's come back at 11.
Yo.
Does the court mind that we stay here?
Doesn't matter to me.
Yo. This is absolutely insane.
Okay, so if that's fine, that's fine. But I'm not going to ask them to stay here. They've got a lot of other work to do too. Okay.
So, of course, the state is not prepared as normal, as usual. This is absolutely insane. And excuse my voice again. I'm a little bit under. So I apologize. This is so unfair. Yeah, it's not even funny at this point. It's not even a joke. Okay. We're going to go ahead and get into this into this motion that Mr. Weinstein did this morning. Thank you shout out to Dre XO, one of the best mods in the game, who was able to find this and was able to give it to me. It says, in my opinion, they just want a chance to start over. Yeah, but I think it's deeper than that now at this point. It's the fact that not only do they want to start over, but they wanted to have an advantage, and the advantage was Glanville. They had an ex parte meeting on June 7th as well, which stated the assumption that the defense was in cahoots or co-conspirators with YSL, accusing defense to be or act in a certain way that is unprofessional. Like, they're assuming as if they are in cahoots with the actual operation of this organization that is producing or doing RICO, and saying certain things and behaving towards Max Sharp a certain way and behaving towards Steele a certain way and trying to figure out why is it. And everybody, think about this. Everybody was like, why is he always going at Sharp? Why? Every time Sharp says something, Glanville be in his ass. Like, straight up. I was saying this. Even it was exactly, it was blatant. It's like, dude, every time Max Sharp say something or object to something or say anything, I'm talking about from the very beginning of this trial. From the very beginning, he had a certain type of tone with Sharp that he didn't have with everybody else. And everybody like, yo, why is Glanville going ham on this dude? Come to find out, he already had a bias on him. And then and then you discuss you discuss the defense counsel in an ex parte meeting, and you discuss accusations and presumptive accusations in an ex parte meeting, not just on June 10th, but also on the day that you arrested Woody. on the day you arrested Woody, June 7th, you already had an ex parte that day that no one ever knew about, that you were never going to tell the defense about. As a matter of fact, you did not tell the defense about it, and then they found out about it yesterday. They found out about it yesterday. So here it is. They find out about the ex parte meeting yesterday. Then you get the transcript. They read the transcript, and all the things in the transcript is trashing the professionalism of the defense. And you mean to tell me that they're supposed to be okay with this? Sheila, listen, it was heated today already. They're on an hour and a half break. They're going to come back at 11 o'clock. And in the meantime, we're going to talk about what we just saw, and we're also going to discuss this motion from Mr. Weinstein. So they've been talking behind the scenes for me. Exactly. And this is the part that is so uncomfortable. If you are an American citizen and you live in the state of Georgia and you watching what's going on right now, there is no way you should have any confidence in the judicial system of the Atlanta circuit, at least. Skip the country. All right, skip other states. Let's just deal with the Atlanta judicial circuit. If I'm watching this, I don't ever want to get a traffic ticket, because it seems like they can stack a traffic ticket against you based on what we're looking at. And Weinstein being very adamant, but Max Sharp, shout out to Max Sharp. Everybody put Max in the chat real quick. Put Max in the chat real quick. Because Sharp said, hey, man, I am not pleased with what's going on. He said it already yesterday that this case is broken. This case is broken. He said it already that this case is broken. There is nothing about this case that is proper when it comes from the state side. They want the defense to render evidence for what? It's not the defense turn to rest their case. You're resting your case right now. You need to turn over evidence. I'm not going to prematurely give you evidence when it ain't my time to rest my case. It ain't my time to rest my case. So don't ask me to give you anything. This is absolutely atrocious. As AV would say, this is debauchery. And I know the lead attorney and all them probably over there right now, man. It's got thousands of people watching them, and then shout out to them. But we just gonna keep it being from the layman perspective. There is no confidence that I have in the judicial system after seeing something like this. This is the most talked about RICO case in the world. In the world. It ain't just America saying this. It's the world saying this. The world knows Young Thug. Do you feel confident look at your county, look at your area. Shout out to Detroit. I'm born and raised. I'm from Wayne County, right? Born and raised in Detroit. But let me tell you something. I do live in Indiana at this point because of my career. And let me tell you something. I live in Marion County in Indiana, which is one of the largest counties in Indy. Let me tell you something. I ain't trying to get no more trouble. No trouble. So at the end of the day, if I'm looking at this from just a regular citizen's perspective, there is no confidence that I have in the judicial system at all. Not even a little bit of confidence. I'm starting to get my voice back a little bit. Not even a shred of confidence do I have in the judicial system. You had a meeting where you pretty much put a shat on the defense and individually, and you said individuals' names? You said individuals' names on top of that? And now we see why you was acting a fool on Max. Oh, but see, this judge is like, oh, well, he's recused, so that whole situation is done away with. No, she is living under a rock right now. You have to unpack. You have to investigate everything about this case. Stop skipping over the details. The devil is in the bloody details. Stop looking over the details in this case. Go precept by precept when it comes to this case. Everything about this case is corrupt. Even if I'm guilty of something, the prosecution cannot be corrupt against me, especially if it's their case in chief. They're the case in chief right now. So it's your job to prove that I did something. You keep filing motions for my counsel to give you evidence about me when it ain't our turn yet. And you want to make it seem like it's okay. And this judge she's in a rush. Slow down, judge. Slow down. Look at every single thing that's happening in this case. You're talking about the state is not prepared and all that kind of stuff. You haven't finished reading the damn transcripts. You didn't read all those case laws. You didn't do all of that. Ain't nobody stupid. And you got the nerve, the audacity to rush the defense and rush everybody else to do their job. When you are coming in this party late as hell, let me tell you something about the club. When you get to the club and the lights are on, that means you're late. She coming in the club when the lights on. Ma'am, you late as hell. You late. You didn't get in at 10 o'clock. When it first started popping, you know how you go to the club and first start popping 10 o'clock? You know what I'm saying? You get about 11, everybody start rolling in for real. You know what I'm saying? It's all dark and dim and that boy, you're like, then did it on tonight. You know, you're doing all that. And then here comes somebody trying to come in the club at 1 o'clock in the morning. The lights is on, last call for alcohol, and they coming in acting a damn fool. Hey, man, you ain't been here all day. Why you coming in with this bull? And this is the judge. She coming in the club late, lights is on, and she trying to order food. You trying to rush everybody to do what they need to do. They've been working. They've been working all night. You trying to tell the bartenders to hurry up and get there, make your drink. It's 1 o'clock. There are some places where the club closed at 2, but they start shutting down at 1:30. It's 1 o'clock. You're going to try to rush me to make you a drink? How come you didn't get here at 10:30, 11, 12? When I was in my zone. You trying to come in late and then tell us to hurry up and rush and don't do this. Well, this doesn't make sense about this. I believe that they were doing it. That's speculation. You're speculating. And you know what's so funny about this judge? Yesterday, she was so hell-bent on the transcript and saying, hey, Brian Steele, why do you have to examine Judge Glanville on the stand when it comes to cross-examination or making him a witness? Why do you have to do that? Shouldn't the transcript be enough? Now, all of a sudden, she like, well, the transcript ain't going to be good enough. We need more proof. Wait, what? I thought you said the transcript was good. You're so black and white. You're so there's no gray at all. This lady is irritating me. Exactly. Breaking the law to try to uphold the law. That's a great statement. You can't break the law to uphold the law. And in this case, the state is like, oh, yes, we can. Because wow, we got Fonnie Willis. This is absolutely insane. All right. I'm ranting right now. This is crazy. Did we just see this? What did we just see, man? We saw another ex parte meeting on June 7th, and we saw the defense response to it. It is July the 31st. This meeting happened on June the 7th, an ex parte meeting. And in this ex parte meeting, they trashed the defense, threw them under the rug, called them out by name. Oh, yeah, I noticed this about them. I noticed this about them. And then they get the transcript for it, and the emotional outrage, which is definitely warranted. The judge is telling them, well, everybody just calm down. I can't take my glasses back up. I can't stand a person who tells me to calm down when I ain't done nothing. I haven't done anything. You're talking to the wrong person. I hate these generalizations when it comes to accountability. It's like, oh, like Miss Love just did this morning. Well, Your Honor, make sure that we all are being professional. You know, being called a co-conspirator is not a professional thing. Really? Really? You've been unprofessional since the genesis of this damn case. You were unprofessional in your opening statement. Your opening statement was a mistrial. Hold on. Let's talk. Let me tell you something. Hold on. Let me see something. Because this chick is nuts. This chick is absolutely insane. Let me see something real quick. Because this whole thing should have been a mistrial from the opening statement. Dog it. Let me see. One of the things about an opening statement, right? I can't find my stuff right now because I'm live, so I don't have the time. But one of the things about an opening statement, if you withhold certain things from an opening statement that you're supposed to render over to the defense, that could cause a mistrial. If you try to swing the burden of the jury, that can be a mistrial. If you try to do anything when it comes to your opening statement, if you try to swing the burden of the jury, if you try to withhold information that you're supposed to give over to the defense, if you try to tell the jury that the defense need to prove something, all those things right there are leading. All those things are burden swinging. When you try to swing the burden of proof, and when you withhold information, or if you include information that you said you were going to exclude in your opening statement, that can cause a mistrial. And that's exactly what happened the first day of the trial, the opening statement. Miss Love effed up. She effed up her own opening statement. She effed it up. And you know what the judge did? When Brian still had the motion for mistrial, you know what happened? Nothing. He didn't have a hearing, or it was blatant. She used a slide in her presentation that included the defense's name as if he was the representation of this particular client. She said that she was going to exclude that, and she did not give over the entirety of her opening statement. And guess what Slimeville did? Absolutely nothing. He denied the mistrial. I'm gonna deny the mistrial in this point in time. He's the most point in time Negro I ever met in my life, man. In this point in time, here it is now. We are 100 some days into the trial. Here it is. We are 100 some days in the trial, and then all of a sudden, we have another ex parte meeting on June the 7th, the day that Woody got arrested, that you're trashing the defense. And then, I mean, hard. Talking about Max Sharp, everything. And you've been riding Max Sharp for the longest. Chile, I got you, Chile. I'm over here ranting. I'm sorry. But Weinstein's new motion was actually filed 7:15 a.m. this morning. All right. So we're going to read this. I have not read this. I have not seen this. We're going to read this together. All right. And again, I apologize. I'm a little bit upset. I'm like Max right now. I'm a little bit upset right now. I can't believe that here it is the whole time my gut reaction was the truth. All right. Excuse me. And I have a sore throat, so this is not helping. State of Georgia versus Diamante Kendrick, which is the Douglas Weinstein is the representative of Mr. Kendrick. Let me go ahead and blow it up just a little bit more. Hold on one second. Okay, is that better? Can anybody see that? Says supplement to Diamante Kendrick's motion for retrial. Says comes now Diamante Kendrick, petitioner by and through his undersigned counsel, and brings this supplement to motion for mistrial showing as follows. Outside agitator is a term that delegitimizes internal dissent against the status quo. So anyone who speaks up against the status quo, whatever that is by definition an outsider. Professor Dylan Pendergroff, UC Berkeley. Says here that Judge Glanville making outrageous allegations against members of the defense teams in the present case. Quote, but I think it does in some way outside agitators and everybody else who I think are trying to influence. The third ground argued in Kendrick's motion for mistrial is that Kendrick's due process rights were violated relating to a 14th Amendment due process violation relating in part of Chief Judge Glanville wrongly coercing Copeland to testify. Further evidence of the state and Judge Glanville's violation of Kendrick's due process rights has just come to light. Just come to light. Just come to light. Yesterday, we see. Okay, Exhibit A got the. Okay, we about to get into this. Shout out to Drea. We about to get into this. All right, I'm getting my voice back, y'all. The more I talk, the better I feel. Yesterday after court, yes, Sheely, there was an ex parte meeting on June 7th of 2024. Yesterday after court, Kendrick received a rough transcript, Exhibit A, of an additional secret ex parte meeting with Judge Glanville. Can we just go to Exhibit A? You want to just go to Exhibit A? Put a one in the chat if you want to just go to Exhibit A real quick. Put a one in the chat if you want to go to Exhibit A real quick. This is absolutely insane, yo. This is absolutely crazy. Yo, let's go to Exhibit A. Let's just do it. Let's just do it. Whoa, wait a minute. Whoa. It is not a fair trial when in an ex parte meeting, Glanville and Love have the following outrageous conversation. But I think it does in some way outside agitators. That too. And everybody else who I think are trying to influence. That is absolutely happening. Hold on. Oh, we got action. Okay, we got action. 2:45 p.m. This is Exhibit A. Yo, this is crazy. Okay, let's go ahead and do this. All right. Says Miss Love, Judge, the reason that we wanted to, the reason that I specifically wanted to talk with you is that I have a concern about the representation being made of the representation of Mr. Copeland. I am concerned, and I am sort of not. I'm concerned, and I am sort of not. I wanted to just bring it to the court's attention. Mr. Melnick has not conveyed to either Ms. Hilton, myself, or any member of the state any legitimate concern that he has regarding Mr. Copeland's testimony. What we have seen in physical interactions with persons beyond, besides Mr. Copeland, that would indicate that Mr. Copeland is not Mr. Melnick's primary priority. What we do know is that when the fact that he's willing and wanting to leave, number one, I hate the way she talks. He left twice after the court ordered him to speak with his client. And it would seem his actions convey that it is not Mr. Copeland's best interest that is priority. Miss Hilton was out speaking with Mr. Copeland, and Mr. Copeland's request at the time that I announced that Miss Hilton was calling Mr. Copeland. What I did not know is that she was trying to tell you to give us a minute because Mr. Copeland was feverishly, and I will let her speak as to how that went down, feverishly trying to get her in there to convey to her something that Mr. Melnick had just said to him that did not come from any of us. The court. What was that, Miss Hilton? That's Glanville talking. Miss Hilton. So let me just put the order of operation. I got up because Deputy Long and Deputy Chief Long said he wants to talk to you. Come out right now. So when I went into the room, Melnick either came in or came outside. And what Mr. Copeland said, and I think that he wanted to get some autonomy. I want to talk to you. He's like, I've already talked to you, but I want to talk to her. And Mr. Melnick kept like blocking him being able to talk to me. So this was when this is when that time where she said that he came out of nowhere. Remember, Melnick told them, I have a meeting that morning. That morning, Melnick had a meeting in the same courthouse. Okay. It was in the same courthouse. I believe it was upstairs somewhere. He said he would be down there. Don't talk to my client unless I'm there. They knew that. So eventually I was like, well, clearly you want to talk to him. So I'll step out and you can come in. Mr. Melnick spoke to him, and I think he was trying to eat up time because he knew that you were coming out. So by the time I got back in there and he started to talk, that is when everyone said, come on, the judge is waiting. And that's why he stormed in angry. Miss Love, he being Mr. Copeland, Miss Hilton, because I think he was trying to convey to me some concerns he had. And so I was trying to have that conversation because Mr. Copeland and I have been having really good conversations since Friday, like very, very good conversations. Just not even about the facts of the case, but just life experiences. What, she was trying to get to know him or something? Were you trying to get to know him? So I think I was building a rapport, there you go, with him such that he thought I lied to him. So I was trying to explain to him, Ms. Love, and by that she means today. Wow, today. Ms. Hilton, today about what was going to happen. Ms. Love, because of what someone conveyed to him. Ms. Hilton, we believe that something was being conveyed. What happened is, as Mr. Copeland was walking back into the courtroom, Mr. Melnick and Julie would have to, Miss Lancequat would have to confirm this, but he said they are going to hammer you. And that made me ask Miss Love, did you say something about hammering him? And I don't know who. Miss Love, nobody did. Nobody did. The court, it doesn't make sense you would say that to him. Miss Love, we never said that. The court, but anyways, okay. Miss Hilton, so whatever that communication was, that's when he stormed in and got angry. And the result I got was that he gave when we started, and the result I got was what he gave when we started. So at this point, I'm very concerned, Miss Love. He, meaning Mr. Copeland, stormed in and got angry. Miss Hilton, the timing of everything is very ironic. We laid it out on the record earlier about what happened, and I don't believe that Mr. Copeland's best interest is being served at this moment, given that, I mean, Mr. Melnick was willing to take a vacation and let him languish and just, oh my God. She is such a manipulator, bro. She is such a manipulator. Jeez, oh Pete. I mean, Mr. Melnick was willing to take a vacation and let him languish in jail. And that is not. We have communicated that we never wanted Mr. Copeland to go to jail. We don't want him in custody. We don't want any of that to occur. And so here comes Miss Love. Miss Hilton and Love, they're both manipulators to me. Here comes Miss Love. And Mr. Melnick has not spoken. He has not relayed. What we did get during the break was an email from Mr. Melnick. I don't know if he had to have been blind copying someone else. The only two people I could see on the email were Miss Hilton and myself, but he referred to me in the third person and said, these are the communications between myself and Miss Love. So I asked Mr. Melnick, whose interests are you concerned about? Your clients or Mr. Stills and Mr. Sharts? Look at her asking this insulting question. Because prior to, and this is not the first time Mr. Copeland he has said, he doesn't represent me. This is not the first time Mr. Melnick has, and let me be real clear. When he spoke of what was happening before him representing Mr. Copeland and he told me that he didn't represent Mr. Copeland. He told me. Mr. Melnick told you? That's what Glanville. Mr. Melnick told you? Miss Love, yes. Mr. Melnick told me previously that he wasn't representing him. Now, that is an actual that is very disingenuous, because Kenneth Copeland, Lil Woody, has been represented by Melnick before. As a matter of fact, before Melnick represented Copeland, Miss Bumpers represented Copeland before. This goes back some years. And he got rid of her, and Melnick stepped up to represent him. So remember the interrogation video that came out, that was leaked out, by the way, for hours and hours, when he talked to the investigative detective or whoever, I forgot this young lady's name. She asked him, do you want me to contact Mr. Melnick? Specifically said his name. They already knew that he had representation. They are twisting the words. Excuse me. You would, this is crazy. The court, you would not speak to an unrepresented party. I mean, I know you enough. Excuse me. Excuse me. I know you know enough of the rules to know that if you thought or intimated that somebody was represented by counsel, you would go ahead and let them contact that lawyer. Ms. Hilton, or Mr. Copeland would have said, because I don't know as a witness, because he's not charged, if we would have had to. Ms. Love, right. Excuse me. So Ms. Hilton says, because he's not charged. The court, I don't think you have to because there's no pending charges. But if he told you, I got a lawyer, I don't want to talk. I don't want to talk to you. Ms. Love, we would have left the court because people counsel, excuse me, that they have under retainer or something else, or they say, hey, I got a lawyer that I use for everything, and I want to talk to him. I'm not comfortable talking to you unless my lawyer is present. Ms. Hilton, we have done that with a number of our witnesses here. So this would have been no different. I gotta make me some more tea. I gotta make some more tea. I had some coffee, but I gotta make some more tea. I appreciate you, Sheely. Excuse me. Miss Love. Exactly. And we would have, I'm sorry. I don't mean to cut you off. Miss Hilton. Oh, no. Go ahead. That was it. We actually communicate, Miss Love, especially when either they are incarcerated or subject to having their sentence revoked as a result of their testimony because they pled guilty here. We only reach out to them through their attorney because we want the attorney to speak to them and for that to be because that's the best way, in our opinion, to get a rapport that elicits truthful testimony. So in this particular instance, there was not that. That's number one. There was not the communication made by Mr. Copeland that there was ever a need for that. This is bull. This is BS. This is such BS, man. And two, there was not a need for us to be concerned about it because he doesn't have charges. Everybody tell me to stop getting now. Okay. Listen. Give me a few minutes here. Okay, listen. We're going to do this. We're going to stop right here. But what we'll do is this. Because, man, we're going to talk about some stuff, man. But I appreciate y'all keep looking out for me real quick. Let's take a look at Miss Love's opening statement. Let's see if we can get the full thing. I'm going to. Oh yeah, this is good. This is so good because she was she thought she was doing something too. All right. I'm going to go ahead and play this. Okay. This is the opening statement of Miss Love. This is where the mistrial should have been granted. All right. This is where it should have been granted. I'm going to go ahead and play this real quick, and I'm going to make my tea. I will be back. I'm under a little bit. I'm going to refill it now. But watch this particular video here of the opening statement where she clearly completely messes up. All right, here we go.
I'm going to now share my screen with court's permission.
Yes, ma'am. Go right ahead.
Thank you. Now, this is the law of the jungle, as old and as true as the sky. And the wolf that shall keep it may prosper, but the wolf that shall break it must die. As the creeper that girdles the tree trunk, the law running forward and back. For the strength of the pack is the wolf, and the strength of the wolf is the pack. Thank you so much, ladies and gentlemen, for being patient. Thank you so much for being honest during this very lengthy process that preceded this point here today during the voir dire process. I appreciate you all being here, exercising your civic duty, and
honoring your obligation to pay close attention to what's going on in this courtroom for the next several, however many weeks. Some people like to say that opening statements are a roadmap to what the trial will show. Instead, I'm going to give you an overview, a bird's eye view, because you're going to be sitting here with evidence for the next several weeks at least. And you will be able to see what that evidence is. Nothing that I say to you during this part of the trial, nothing any other attorney says to you during this part of the trial is evidence. But I can tell you what I expect the evidence to show. And what I expect the evidence to show in this case is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. The quote that I read to you earlier is from one of my favorite books as a kid, The Jungle Book. In case anybody recognized it, those were Rudyard Kipling's words and not mine. But they are appropriate for where we are today. For 10 years and counting, the group calling itself Young Slime Life dominated the Cleveland Avenue community of Fulton County. They created a crater in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members. Now, the evidence is going to show that this group started out as a group called Rock Crew. And Rock Crew stands for Raised on Cleveland. The evidence is going to show you that Rock Crew, in fact, is a criminal street gang. It's not the kind y'all are used to. If you're more familiar with the national gangs, such as the Bloods and the Crips that operate in LA or in Chicago. But make no mistake about it, Rock Crew is and was a gang. It consisted of 3 or more members with common identifiers, signs, colors, linguistic choices that committed crimes on behalf of and in furtherance of Rock Crew itself. That particular organization aligned itself under an umbrella of a larger, more traditional street gang called Sex, Money, Murder, Bloods. They adopted the nomenclature. They would do things like replace C's in words with the letter B, because traditionally Crips and Bloods were not aligned with one another. So Cleveland Avenue became Believeland. Some of you may have indicated during voir dire you've heard or are familiar with the Cleveland Avenue area. Maybe you've even heard of Cleveland Avenue Day. The evidence will show that this is where that comes from. The evidence will also show that sometime in 2012 or thereabouts, an internal rift or divide occurred among the members of Rock Crew. Now, the defendant, Jeffrey Williams, seated back there yawning right now, he was an original member of Rock Crew. And the kind of crimes that Rock Crew did consisted of smash and grab burglaries, stealing ATM machines, things of that nature. When Rock Crew split up, YSL, or Young Slime Life, was formed. And the defendant, Jeffrey Williams, was its proclaimed leader. Young Slime Life came about and consisted of 3 or more people when it began. 3 or more people who were willing to and who did commit criminal street gang activity, that is crimes, that were intended to further the purposes and advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL, because this was a group of people associated in fact, who used common identifiers, common names, common colors, common symbols to communicate with one another and to express themselves to the rest of the world. So YSL, as the evidence will show, they didn't move individually. The members and associates of YSL, they moved like a pack, with the defendant Jeffrey Williams as its head. You'll hear from witnesses, both law enforcement and lay witnesses, who personally experienced and who personally witnessed the activities, the crimes that were committed. You will hear from law enforcement officers like Kimberly Underwood and Tyrone Dennis, whose main goal wasn't to go out in the streets and lock up people who looked like them. It was actually to touch souls in the streets, to touch young people, and to alert them of the dangers and the drawbacks of becoming a part of and becoming involved in gangs like YSL and Rock Crew. You'll hear about conversations with educators. You'll hear from members and associates of the gang itself. Now, as to how those members and associates will respond or act once they're actually in court and on the stand, that's something that I am truthfully not able to predict to you fully. But the court has given you instructions on determining and judging the credibility of the witnesses. And I trust that all of you will in fact follow those instructions. The evidence will show that YSL checked all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery, hijacking, motor vehicle theft, theft by receiving, stolen firearms, so many stolen firearms, possession of a machine gun, and narcotic sales. And last but certainly not least, murder. What you will not hear any evidence of is that the defendants were not involved in a criminal street gang. You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now, this is
Let me object to that statement, please, as burden shifting.
Object basis?
Burden shifting. And under Parker versus the state at 277.
Why don't we take that up then?
39.
I'll note your objection. I'm sustaining the objection. Why don't you rephrase, madam?
yes, Your Honor.
Just rephrase it. Ladies and gentlemen, I'm going to explain to you at the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier, that the burden never shifts to the defendants to prove for certain innocence, they're presumed innocent. And it's only until you hear evidence that you decide is sufficient, and I'll instruct you on how you're supposed to do that at a later point in time, okay? All right.
The evidence will show that YSL did not adhere and does not adhere to all of the customs of a traditional street gang. And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. The defendants on trial here today have, through their actions, displayed not only their allegiance, their alliance with one another and with the gang itself. Through their actions, they have displayed an unspoken agreement to participate in that gang through a pattern of illegal activities. And again, the head of this gang is seated in this courtroom too. Show that they are agreeing to participate in this organization, this enterprise, through racketeering activity. You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses, whole houses.
I wanted to get to the
drug sales were conducted,
to the mistrial part,
where they held long-going guns by the door, where they stood ready to act on command if either one of their number called. Who's on trial before you today is Rodelius Ryan, Famarius Nichols, Marquadius Huey, Jeffrey Williams, Shannon Stillwell, Diamante Kendrick. And their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor.
You have an objection?
Yes, sir.
Basis.
A motion.
Brian, YSL still for a motion.
All right. Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters at your deliberation room, and we'll call you back in just a minute, okay, when we finish up our business, all right?
This part
of the
was
court's
very, very
admonitions,
interesting.
ladies and gentlemen. All right, please be seated. Our jury has left us. All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder and I represent the co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to this honorable court's attention? 1. And 2, how do we just violate court orders? So yes, I have a serious motion for a mistrial because it's intentional misconduct. That's my motion.
All right.
And I'd like the screenshot to be captured for Mr. Weaver to put in the record.
I'll admit it is next court exhibit in order of the state's presentation anyway, so. All right, So that'll be court one for purposes of the trial. So Ms. Love, what's your response to Mr. Steele's assertion about Mr. Ryan?
As it relates to Mr. Ryan and the exhibits that the state intended to play and to display for the jury, I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use. As it relates to the slide to which Mr. Steele is now referring regarding his representation on appeal, I'm not certain if the objection goes to the fact that there was the conviction, because that's part of the indictment and that's part of the evidence that the state expects will show, or if it's as to his objection about the fact that he represents Mr. Ryan or Mr. Blaylock on appeal.
Don't represent Mr. Ryan.
Mr. Blaylock, then.
Excuse me. I was never said this ever. That's it.
So what's your objection based upon, Mr. Steele?
Objection based upon, I argued this before this honorable court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
Brought up to this honorable court, outside the presence of everybody. We're an open statement. I am lied to. I am saying that. I am lied to. Or if anyone else got that exhibit, I did not get that exhibit. And I'm seeing everyone say shaking no. And now it goes against the court's word. We are bound, duty bound to follow some of the court's word.
Mm-hmm.
Can I join in the objection on behalf of Mr. Steele?
Let me see the.
I can put it back up,
Yes,
Judge.
ma'am.
And Your Honor, while I am putting
Watch
that
this.
back up,
When she put it back
I will
up, you're
state
going to
in my
see his
brief
name
that
on it.
Initially, when there was the objection from Mr. Steele, I didn't have a clue what it was about because I didn't mention his name and didn't intend to mention his name. As I looked at the screen, I saw that part of his name was on the screen for the most part.
But I mentioned that, I ruled upon that last week. I did. That we were not, I would take it as it came in this case. And if the evidence got to that point, then I would deal with it accordingly.
Yes, Your Honor.
So,
and Your Honor, as to Mr. Steele's motion, as I'm pulling
she knew what
this
she was
up,
doing.
the state would vehemently object to a mistrial and ask for a curative instruction and a reminder to the court, to the jury, that nothing that the lawyers say is evidence in this case. This is not at all the type of thing that rises to the level of mandating a mistrial. Certainly not. It just isn't. I have the
You withheld that. You withheld information.
slide.
pull up,
I have it now. I'm
court
about to
has
share the
court
screen.
one for purposes of the motion for mistrial.
Look at that. There it is. There it is right there. You were supposed to leave this whole thing out. She was supposed to leave this entire thing out. She put it in there anyway. I just wanted to show that this was a mistrial from the very beginning, okay? It makes absolutely no sense to have a hearing in the court and then deny mistrial, knowing that the state withheld information and did not hand over all the information they were supposed to hand over to the defense. It's very telling. Very, very telling. All right, I think I'm a little bit better now. Got my tea that everybody told me to go get. So let's get back to this real quick. Let's see this here. Okay. So we are here. This is the right, slime business, right? Exactly. Thank you. Yes, I feel a little bit better now. Thank you all. So let's talk about this for a second here. This is the motion that Mr. Weinstein has given, and that he submitted. It's a supplement motion, and he is referring to Exhibit A of this motion, which is the ex parte meeting of June 7th. Okay, the ex parte meeting of June 7th, not June 10th, not the ex parte that everybody knows about. The other ex parte that nobody knows about. Okay. So Ms. Love says we actually communicate, especially when either they are incarcerated or subject to having their sentence revoked as a result of their testimony because they pled guilty here. We only reach out to them through their attorney because we want the attorney to speak to them, and for that to be, because that's the way, in our opinion, to get a rapport that elicits truthful testimony. So in this particular instance, there was not, is what she's saying. That number one, there was not that communication made by Mr. Copeland that there was ever a need for that. And two, there was not a need for us to be concerned about it because he doesn't have charges. Ms. Hilton explained to him at length that whatever happened that he did in 2015, which is all we're going to be talking about to him about, the statute of limitations has run. He didn't do the murder. We know that. I mean, so I don't want to get into the facts of anything. What I'm trying to get at is the fact that Mr. Copeland, I don't believe, I believe Mr. Melnick has inserted himself in a way that jeopardizes the best interest of our witness. I believe that in conveying to the court that Ms. Bumpus is going to stand in his stead. Ms. Bumpus she was, what is the word I'm looking for? The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey Williams. Ms. Hilton, no, she hugged Diamante Kendrick. Oh, I'm sorry. Okay. So Ms. Hilton says, in fact, she hugged Diamante Kendrick and hugged Mr. Williams. And that's how Captain Kendall saw her. And Captain Kendall had her taken out. Miss Love, she expressed dismay and concern in challenging her right to go interact in that manner with the defendants. Of course she did. She has the right to hug whoever she wants. Yes, she challenged it. So our concern is that it is not Mr. Copeland's best interests that are being represented. These lawyers are a mess. And that only is that the case with respect to Mr. Copeland, who we have no interest in prosecuting, but there is a tampering of sorts going on in this person inserting himself, where Mr. Copeland has been reaching out to speak to Ms. Hilton, and that communication is being blocked by someone Mr. Copeland didn't reach out to. Yeah, his lawyer. Crazy fool. You notice no one said, Mr. Copeland called me. He never said. When we put on the record, when Ms. Hilton said the way I understand it, Mr. Melnick reached out to Mr. Copeland, because the first time we heard an assertion like, oh, he's going to plead the fifth, is when Mr. Melnick sent an email to Ms. Hilton and myself, and had copied on it Mr. Steele and Mr. Sharp last night. Okay. The court, why would he have done that, given, and that's the state's concern? They'd be cutting each other off like crazy, man. What was the rest of what he was going to say? Miss Love, that's the point. The court, here go Glanville. But here's the challenge. The challenge is you have privileged communications. And unless you've got him being the client, disclosing to a third party that you, that wouldn't be subject to the privilege. That is the only way you are going to. And then Ms. Love, I don't disagree with that at all. I don't disagree with that at all. But if Mr. Melnick, and the thing is, the thing that got me the most is Mr. Melnick is not looking at Mr. Copeland saying, you know, Mr. Copeland, I want you to stay out of jail and I will be here with you. And if they ask you anything that touches upon something that you and I talked about, I will stand up and assert your right. He didn't do that. What he did was he looked over at two people and said, like, I did what I could, shrugged his shoulders, held up the palms of his hands like this, as to say, I tried. There is no reason he would be looking to the right to counsel for the defense like I tried after Mr. Copeland said he was going to testify. That doesn't make sense. The court. Well, there's a lot of innuendo that have asserted themselves. They, being some of the defense counsel, have inserted themselves in this particular process. And that's what, and Ms. Love, my concern is Mr. Melnick's insertion of himself. This is so backwards. He is his lawyer. He can assert himself as much as he damn well please. The court, what are you asking me to do? What are you asking me to do? And what do you think I can do? Now, this is what Glanville is asking Ms. Love. Ms. Love, that is the exercise. That is the homework for tonight. I wanted to let the court know that that is what we're looking into right now, because there is a remedy, because I have faith in our law. I love this. I love this thing. And I know there is a remedy, because this could never have been the first time this happened. It has been addressed. I just have to find it. But I didn't want to be looking for something and not let the court know what I'm looking for, so you are not, so that you are caught off, so that you are not caught off guard when Monday morning or Saturday night or Saturday afternoon we find it and send it to you. What? Oh, yo, woo, the dirtiness. Okay. Look at the court. Okay. Ms. Love, so thank you for allowing us to audience the court with the court. I just wanted to make certain that we did it properly, and we didn't, and we had everything on the record. It is our witness. We have conveyed, it's your witness, but it's not your client. I think they're getting client and witness mixed up. He is the client of Mr. Melnick. You did not contact Mr. Melnick at all about even talking to Woody during the week, because Woody said, remember, I did a video on this, and Woody said, I told them all week long that I was not going to testify. I was going to plead the fifth. Oh, man. We have conveyed to him that he is shielded from prosecution for anything that he talks about on the stand and any use of that. Remember the derivative use and immunity? That's what he got, or use of immunity. And the thing is that we won't ask him that, but this is what he said. Y'all might not, but they might ask me about some things that I have to assert my right on. And that would be a question by question basis. What is he being influenced to? What he is being influenced to, we believe, by Mr. Melnick is, and it's through Mr. Melnick, because as you saw, Mr. Kenneth Copeland said, I will testify. It's okay, Drea. She said, I'm so discombobulated today. It's okay. Mr. Melnick, even after that, said he's asserting his fifth. I'm going to go talk to him. Logically, one would think that as long as Mr. Melnick's concerns about Kenneth Copeland's freedom, legal freedom, and his exposure, as long as those were addressed, Mr. Melnick should be saying, I am here with you. If there is something that I know will put you in jeopardy, I will stand up and stop you. But right now, I would rather you stay out of jail. Instead, you get Mr. Copeland, and you can see through his body language. He gets there in court and he's smiling as if making a show of being taken into custody after this. And the man don't want to be in jail. He said it. Didn't he say he don't want to be in jail? Miss Hilton, that's his biggest fear. They are clueless. That's his biggest fear, Miss Love says. And now he's in jail after Mr. Melnick asserted himself in this process. So you're trying to say this is the most asinine thing in the world. The man already told you he was going to plead the fifth anyway. You talked to him behind his lawyer's back. The lawyer invoked the fifth on behalf of his client in open court. And then Woody goes up to the stand and actually pleads the fifth. But to say that the defense is asserting some things is crazy. And now he's in jail after Mr. Melnick asserted himself in this process. So we have to go figure it out. I'm not just laying it on your lap saying, go fix this. I'm just bringing this to the court's attention. This is a grave concern. Ms. Hilton, she's about to lose her mind because her biggest concern is that Mr. Melnick is actively harming a human being. And that's what she's maddest about. I'm mad because it is stopping our trial and it's wrong. And that is how the law is supposed to work. So we have two big old grave concerns that we are working to remedy right now. The court, Glanville. Okay. Well, like I said, I think that you brought your concerns to me. You know, without more, I don't know what else I can kind of do in terms of that. My comments today were predicated on there's a lot of stuff that's going on in the background, and it shouldn't have to do anything with you all's case. It really shouldn't, but I think it does in some way. Outside agitators. Miss Love, that too. The court and everybody else who I think are trying to influence. That is absolutely happening. Oh, that's what y'all talking about. Miss Hilton, there's a lot going on. Miss Love, there is a presence. Yes. That is all I'll say. The court, Glanville. I mean, but I see it from just being in the courtroom and tracking. But okay, if you find anything, yes, abundance. Yes, this is another secret ex parte meeting transcript that we're reading right now. That happened on June 7th, the day that Woody was arrested in front of the honorable court, where he is asserting the idea that the defense is influencing things in a certain way. She's like, what? Yes. But okay, if you find anything, we'll see where Monday leads us. And I like, and like I said, since we know he's going to potentially invoke, we'll see what his pleasure is. Ms. Love, I mean, just the idea of someone sitting in jail throughout this trial. But if that's what he's being counseled to do, and that's what he does, that's just wrong. It's wrong because a member of the bar is, in my mind, creating that circumstance, you know? That is not what happened. He's going to do what the person he trusts to have his best interest at heart tells him to do, and that person, he doesn't have to tell us what he's concerned about, and can just sit there, and when he sees the train coming, stand up and say stop. But he's got a vacation to go on, so he can't be here. So Miss Bumpus, they already knew all this. So Miss Bumpus is going to be here. Miss Bumpus, hugging Mr. Kendrick and Mr. Williams, is going to be here representing the interests of Kenneth Copeland, who is supposed to testify against Mr. Kendrick and Mr. Williams. That is where we are. That doesn't pass a smell test. Wow. Look at this statement. Look at this statement. She hugging Mr. Kendrick and Mr. Williams. Hugging that doesn't smell. That doesn't pass the smell test. All right. Okay. Ms. Love, thank you. Unbelievable. So Exhibit A has the transcript of the ex parte meeting on June 7th, where they are implying that the defense is in cahoots with the defendants. Unbelievable. Unbelievable. Okay, let's read a little bit more of this. I know, as a matter of fact, give me 1 second. Let me make sure I pull up our feed. Okay, they are not back yet. All right, they are not back yet. Okay. So let's go ahead and read a little bit more of this before they get back, okay? Isn't this not crazy? Like, seriously, this is totally insane. And this is totally insane. And I see why Max, and I see why Glenn, I see why Weinstein, I see why they're all upset. Okay. I see why they're all upset. This is the assertions is crazy. It says here, let's start right here. The rough transcript was helpfully provided by this court to defense counsel. A reading of the rough transcript highlights that which has been obvious to all observers, except for Kendrick's counsel, for the past 19 months. Judge Glanville has been willfully biased and acting as a member of the prosecution team since the inception of this case. Kendrick's counsel takes no pleasure in alerting this honorable court to this situation, but client obligations require it. Again, they are being goaded to do this mistrial. Listen, they're being goaded to do this mistrial, to try a mistrial because they don't have their case prepared properly. Due process requires a fair trial. It is not a fair trial when an ex parte meeting, Glanville, Love, and Hilton gossip like Yenta. What's a Yenta? Who know what a Yenta is? Hold on, let me see. What is a Yenta, man? Hold on. He said Yentas. Yentas. What does it mean? A woman who is a gossip or a busybody is known as a Yenta. Wow. It's a Yiddish, the origin of it is Yiddish. Wow. He called them Yentas. This is absolutely insane, dog. Weinstein went off. Gossip like Yentas over 13 pages of transcript about attorney Sharp, Melnick, and Steele. Absolutely. It is not a fair trial when an ex parte meeting, Glanville, Love, and Hilton assassinate the character of attorney Melnick and attack his integrity, alleging that he is not acting in the best interest of his client, Copeland. Now, to give more context to that, Copeland and his attorney agreed to a severance between each other if Copeland admitted or said he was going to testify. Remember in the other transcript when Ms. Bumpus was trying to understand why, to make sure that like what his jail situation would be if he does not testify, if he does testify, whatever case. I recall her saying that she had a document for Lil Woody to sign in case he testifies. That was an agreement prior to Melnick stepping in on that day. So there was an understanding, because the reason why he was going to sever himself, Mr. Melnick, is because all week long, Miss Hilton been contacting Lil Woody without a counsel represented. She was talking to Lil Woody behind Melnick's back. And Melnick could not do his due diligence as a lawyer to represent him properly because he didn't know what they talked about. So the best interest of Woody was going to be Bumpus. And since Melnick knew that Bumpus had a rapport with Kendrick, with Williams, with Copeland, because Bumpus was Copeland's attorney before, this is the reason why Bumpus was there, to ensure the severance between Melnick and Woody in case he testified. And it was a comment. I'll see what Sheely said. I think that Melnick was saying, if you play games with state, I'm out. Not just that, but also the fact that the state had been talking to Woody behind his back. Remember, Woody was like, y'all been talking to me all week long. I keep telling you, I don't want to testify. I don't want to testify. It's so many different things that occurred. And so these combination of things that happen warrants the reason why Melnick is like, hey man, you keep sleeping with the state and you with me, but you don't talk to them without me. I can't represent you fully. It is not fair when in ex parte meeting, Love lies to Glanville about an email she received from attorney Melnick. It is not fair when in ex parte meeting, Glanville starts talking about outside agitators, stating my comments today were predicated on there's a lot of stuff that's going on in the background. And it shouldn't have to do anything with you all's case. It really shouldn't, but I think it does in some way outside agitators. It is not fair. It is not a fair trial when an ex parte meeting Glanville and Love have the following outrageous conversation, which is what we read. It is not fair. It is not a fair trial when Glanville, Love, and Hilton have this further discussion. There's a lot going on. There's a presence. Yes, that's all I'll say. I mean, but I see it from just being in the courtroom and tracking. What do you mean? And this right here means reference what's been said. Reference what has been noted above you. How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? Woo! Doug. Hey yo, Doug, we gotta drop the bomb on you, Doug. We gotta drop the clues bomb on you, dog. We gotta. That's it right there. How many violations does it take to get to the center of the Tootsie Roll? Dang. This case is like an old house that the present honorable judge is tasked with renovating. That's a great analogy. You're trying to renovate this old house. You need to tear it down because it's out of code. You need to tear the house down. Every time a piece of pasted up wallpaper is removed, more rot is found hidden underneath. Woo! No Herculean effort by the present court can fix the due process violations of the last judge. Jesus. This house must be torn down. What would you say? A mistrial should be declared and retrial barred due to prosecutorial and judicial misconduct that has goaded Kendrick into the present motion. You left me no choice but to file for a mistrial again, and to supplement my mistrial now with the fact that there's been another ex parte meeting about counsel behind their back, and you've been gossiping like yentas. That's what Weinstein said, yentas. Wherefore, Kendrick respectfully continues his request that this honorable court declare a mistrial based on the last due process violations of Kendrick's constitutional rights under the federal constitution and the constitution of the state of Georgia. Signed on this day. And what time did he sign it? What time did he file this? 7:15 in the morning. Unbelievable. Sheila said, I hate it. I missed earlier. I can already guess that Whitaker would try to clean it up and sweep it under the rug. Let me tell you something. It was hot. It was hot this morning. First of all, shout out to Max Sharp again, because he came out the gate like, look, I'm sick of this. I'm sick of this. I'm sick of the whole thing. I'm sick of the whole thing. What do y'all think about that motion? What do y'all think about what Weinstein said, y'all? He put the transcript, the rough transcript, he put it in his motion and said, look, all these violations are going on. All these violations are going on. Why not give us this mistrial? How many times does my client have to be violated before he get his rights provoked? I'm telling you, man. I'm telling you. Doug Weinstein, bravo. Bravo. Now, Doug Weinstein is saying, look, you are charged with a huge task, Judge. You're not going to be able to renovate this house. You're going to have to tear this house down. Let's go back to court.
Prior inconsistent statement, and whether or not the fact that Mr. Copeland said, I said it, but I lied, if that would be grounds to, would that still be considered a prior inconsistent statement? And Your Honor, I have three cases for the court.
Okay.
I have Green v. State. I have a copy for the court, as well as a defense counsel. You're welcome. Green v. State, which is 317 Georgia 250, which is a 2023 case. Sconners v. State, 318 Georgia 855, which is a 2024 case, Your Honor. Sure, Sconyers, SCONYERS, v. State, you're welcome. And United States v. Odom, which is a federal Sixth Circuit, United States Court of Appeals case for the Sixth Circuit. It is an older case. It is a 1994 opinion, and it's 13 Fed 3rd 949.
Okay.
May I approach with those three cases?
Yes, thank you.
Oh, sorry, and I'll give it to you. Give me 1 second.
Thank you.
I gave you green already, Mr. Long. I gave you green already. Which one did I give you? Okay, you're welcome.
Thank you very much.
You're welcome.
All right, so Green seems to say that if you say you don't remember, that's a sufficient foundation. Is there, and that's the only one I've looked at so far, is there one that says, if you say, yeah, that was a total loss?
Yeah, so that's also in green, Your Honor.
Okay.
So if you look at page 5 of the opinion, Your Honor, about the 4th paragraph down in the facts of that case, Your Honor. It says, during the course of their investigation, officers interviewed Corey Milton, who said that he knew Green had a green Camry, that Green told him that a cracker bucked, I shot him, and that it was not Baba, Hill's nickname, who shot someone. The state played this recorded statement interview for the jury at trial. However, before the interview was played, Milton testified that he did not remember an interview or Green telling him about a murder, stating, I be getting high, I don't know. After a break, Milton testified that he did remember telling law enforcement lies to try to get out of trouble and that he would say anything.
Okay.
Milton further testified that the investigators brought up his criminal record, including a federal conviction and state charges that were dismissed, and that during the conversation about Green, Milton was looking for help with his case.
Okay.
And those facts are analogous to what Mr. Copeland has said so far on the stand, that he was just trying to finesse his way to get out of trouble, that he said those things, but they were all a lie. And here, our Supreme Court in Green said, a witness's failure to remember making
All right, so hang on. You're talking too fast for the court reporter to take it down because you're reading.
Sorry.
And then where are you reading from?
Now I'm on page 7, Your Honor,
Okay.
Division 3.
Okay.
And when the court, the analysis is a witness's failure to remember making a statement may provide the foundation for offering extrinsic evidence to prove the statement was made. They cite London v. State, which is 308 Georgia, 63 at 66, pages 66 through 67. They further cite Bridgewater, which is 309 Georgia, at Penn site 887. Which cited defendants denied recollection of making a statement, provided sufficient foundation for the state to present extrinsic evidence of the statement. Here, the state laid the foundation for the admission of the recorded interview when it asked Milton twice if he recalled making the statement, and Milton responded first that he could not recall making the statement, and then that he did recall but had lied.
Okay.
And so that is Green. And we also have Scaniers that discusses primarily that the state does not now have to go through every single inconsistency.
Okay.
But that we can now, the flat out denial of that statement, Your Honor, allows us to move forward in playing the entirety of the statement, Your Honor, without going into further details. That's kind of our summation of Scaniers.
All right.
And then Oldham, Your Honor, is a federal case on the same point as the Green case, Your Honor.
Okay, thank you. Appreciate it. Counter law, counter position from any of the defense attorneys?
Your Honor, I'm gonna let someone that's better than me respond, like Matt Sharp or someone. But I just want to state that the foundational element for this argument doesn't even exist, because we don't know what Mr. Copeland has testified to. I mean, everything he testified to after the 12th is void.
You mean we don't know what he is going to testify to?
Well, we certainly don't, because we...
Right. No, I mean, I don't think anybody disagrees with that.
Okay.
But what I said was, let's go ahead and things that we think are very likely to still be an issue, given what he may testify to, let's go ahead and try to, hash out the admissibility of. So true, yes, he may get up there, who knows what he's going to say. But yeah, I mean, he would have to say something that would give a foundation in order for it. But assuming that he testifies generally in the same way that he did before, which was, according to y'all, and I've seen some of it, that was a complete lie, then we will face this. And so let's figure out what the...
So we're guessing at what he may say based on what he said.
Right, because I am trying to get prepared ahead of time instead of having to do all of this while we have the jury. So yes, absolutely.
Thank you.
Okay.
And if for anything, I do remember that there were at least 2 full days of testimony from the 10th to the 12th. And it's the state's remembrance that the I lied started early in his testimony. So, but we can.
Thank you. And with regard to that, the court reporter has said that she probably, what did she say, Ms. Firstfield? You talked to her, I didn't.
She is working on the transcripts of Mr. Copeland's testimony, and she said by either late today or tomorrow morning, she should have, I believe it's June 10th. Sorry, June 11th, and then we'll be working on June 12th shortly thereafter.
And do we already have June 10th, or did he testify at all on June 10th?
He testified on June 10th, 11th, and all of the 12th.
And did he take the stand? He took the stand at least on June 7th, right?
Took the stand. I asked 3 questions in that.
All right. So do we already have the 10th? Somewhere? We'll figure that out. But anyway, it should all be forthcoming soon. Okay, Mr. Steele.
Your Honor, I don't think that the state's cases, from what I heard, I did not read them, I just heard the discussion, are what we're looking for, because those cases are, I don't remember, or I was on drugs, or I don't recall, but I found a case, it is pre the new evidence code.
Okay, so hang on just a second. So I didn't know, did y'all didn't, it's fine if y'all don't have copies of it, but you have the site to it. But looking at it, it does actually look like, in addition to saying, I don't remember, reading right from the case, he says, Milton testified that he did not remember an interview or Green telling him about a murder, stating, quote, "I be getting high, I don't know." After a break, Milton testified that he did remember telling law enforcement, quote, "lies to try to get out of trouble," unquote, and that he would, quote, "say anything," unquote. So it sounds like that is pretty close to what we've got.
Well, okay, maybe I have to study it, but I found a case. Now, my understanding of 24-6-613 is it did not change much of our former evidence code. So I'm about to give you a case from 2011, but it is obviously, if you disagree with that, then it should have no application if it doesn't carry forward.
All right, so you just said 623?
24-6-613, if I said 23, I meant prior inconsistent statement.
Okay.
That's what the state is traveling under that.
Yeah.
And then prior or impeached testimony or testimony by contradiction. So I found this case, if you don't mind pulling up, or I can email it. Johnson, Johnsson versus State. Your Honor, it's 289 Georgia at 106. It's Division 3. That is 709 Southeast 2D 768 2011. And I think that it's on point bad for Mr. Williams, but it says over objection to trial, but we just follow the law. So over objection, the trial court allowed the prosecutor to play the entire tape of an out-of-court police interview of a witness for the state. Johnson urges that the particular statements made during that interview, which were inculpatory of Johnson, were inadmissible as prior inconsistent statements because the witness had admitted making them, but testified that he lied to the police. Then it says, however, the fact that the witness admits that he or she made the prior inconsistent pre-trial statement does not render it inadmissible. We have rejected that assertion that a prior inconsistent statement is admissible only if the witness denies making the prior statement, but not if he simply disputes the truth of the earlier statement. There is no such denial requirement under, and again, it's I don't want to mislead the court, it's under the former 24-9-83. Then I looked at Cummings, which is cited, which is CUMMINGS versus State, which is 280 Georgia, 831. It's in Division 3. It's a 2000. Now we're way back in 2006. That is actually helpful. It does not support the situation that we have here. In that case, let's see, Division 3.
Yeah, so it looks like in that case, he just refuses to answer whatsoever.
Exactly, which really, obviously, saying I don't remember, I don't recall, I may have said something. Those things trigger a prior inconsistent statement. I thought that's what the Green case is that I have to study that the state just cited. But I wanted to bring to your attention that language that I just gave you out of Johnson is, I thought, right on point and bad for my position, but we just tell the truth. So I want to argue with it. But then we always look back. We're always taught to look back on the cases cited, and that former case doesn't promote that position.
So it appears to me, and I'm just looking at Cummings right now too, but so it looks like the defendants, appellants now at, the appellate stage are saying, hey, a prior inconsistent statement is admissible only if I deny making the statement, not if I simply say it wasn't true. And the appellate court is saying, no, that's not correct. You don't have to deny it. Even without a denial, it can still come in. That does not mean the flip is true, that the other part, not simply if he disputes the truth, is not a way to get it in.
I agree.
So I mean, you can take a look at Green, but Green seems pretty on all fours. So I'm thinking unless I hear something that either overrules Green or causes me to severely question Green controls. And whether he says, I don't remember, whether he says, I never made the statement, or whether he says, yes, I made the statement, but it was a total lie, all three of those, it appears under our current state of the law, would permit then the introduction of prior inconsistent statements under 613.
Well, I'm going to read with your permission.
Sure, yeah, absolutely.
Yes. Thank you.
All right. Thank you, Ms. Hilton. That was a helpful use of our break. All right, so with that understanding, are there other specific evidentiary issues we want to consider? Or do we want to just jump right into hashing out some of the evidence?
Your Honor, during the course, the state also looked at the redactions that we had previously discussed with Judge Glanville for the state as it relates to the January 11th, January 28th, February 20th, and February 21st interviews.
Okay.
We do not have any issues with the redactions as is.
Okay, and those redactions being something that the defense and you all have agreed to?
Or it was what was hashed out during
the state of it. Okay, so were those hashings out done prior to or after the recusal motion being filed?
It was done. 3 of them were definitely done after the recusal motion was filed.
Okay. Well, the one done before the recusal motion was filed, we can go with, however, that ultimately ended up being redacted.
Yeah, I'm trying to recall if the others, I know we were in the middle of playing 2 of them during that time period. I just need to confirm when we actually discussed those 2. So January 11th and February 20th, we actually played those interviews before the jury. I believe we played those interviews on Monday, June 17th.
And which would be part of what either needs to get redone or y'all need to make a, come to agreement on.
And we may have started it on Friday, the 14th, whatever that Friday was before. But for the ones that we did discuss during that pendency, the state does not have any issues with those 4. As it relates to June 11th, the June 10th interview, there are some we would like to revisit. So.
All right, I'm not sure I follow you.
Okay.
So. What you say you want to revisit. So I think first it would be helpful to know which ones were hashed out before the recusal motion? And then we can just say that's what we're going with because that was prior to any issue, and therefore we can stay with that. As for anything that was post recusal motion, unless the defense can come to an agreement with y'all about admissibility, we're going to have to redo all of those. So have y'all had discussions yet about, or I mean, I thought y'all wanted to figure out what was actually done and what wasn't.
And I guess maybe I misinterpreted what the court, I thought the court wanted us to figure out whether or not there were some that we wanted to even object to. And so we're saying there wasn't any that were done that we wanted to object to for 4 of them. I don't know if the defense has any, for 4 of the interviews, we have no objection to the current state of the redactions based upon what occurred.
All right.
And so that's what I thought I understood.
Okay, and that was January 11th, January 28th.
February 20th and February 21st.
Man, she is the queen of cutting people off for real.
And so you will let me know which one or ones of those were hashed out before, and where that is, status quo on that. For the other 2 or 3, whether they were before or after, y'all are good with what was decided, but I'll have to find out from the defense whether y'all are good with what was decided, and if not, what particularly you want to revisit.
Yes, Your Honor.
Okay. And then there was a 5th one.
For June 10th, there are areas we would want to.
And that has not been gone into with anybody yet. Is that true?
No, we did hash out that one as well.
Oh, you want to revisit that one?
Yes, Your Honor.
Okay. Okay. All right, can anybody from the defense give me anything close to definitive about whether y'all are good or want to revisit the evidentiary determinations made as to any of those?
And respectfully, and I'm not trying to belabor the point, but I just need to make a record. Our stance is that our trial judge was not an impartial.
I understand.
And so we don't believe that the issues are just limited to post-serving the recusal motion at this time.
Okay.
So
well,
that's, and we understand.
I am not going to be going back and revisiting evidentiary rulings made before then.
I understand. And I just need to say that.
But yes, for the record, I understand.
This is a very difficult task. I was I think we all were very involved in the negotiations and reviewing of these things. But, as we were doing it, I wasn't taking notes of what I was doing. So I'm trying to put together what exactly was discussed. And part of the problem is we don't have a transcript.
Well, I've got some of the transcripts, but not all of them. So if it would be helpful to y'all to have the transcripts of when the jury's out and y'all are going through, we don't have all of them yet, but I've got certain days. So y'all did that like on the 18th, the 20th, and the 21st, and the 24th, and the 25th, and the 26th.
Yes.
Okay. Which is why I want to use this week to the extent possible to not take 1, 2, 3, 4, 5, 6 different days to do that. Okay, so I'll see what we already have and get that out to y'all. And again, y'all, this is all rough. This isn't official, but it looks pretty clean to me.
And there were extensive emails that went back and forth from myself and other defense attorneys with Ms. Hilton mostly regarding these kind of negotiations. Where we agreed and didn't agree at the time. So I'm trying to check my emails and make sure I have.
So y'all have those or should have those. So.
And that would be a good starting point. I'm just making sure that what I have is accurate to what she has.
Okay.
I'm sorry, I don't have a better answer for you.
Okay.
Keith Adams on behalf of Mr. Williams. Let me kind of echo what Mr. Short just said. It wasn't very involved, and I'll be candid with the court. I have several boxes, and one of those boxes contains my notes. It got to the point where Ms. Hilton and I were kind of back and forth in court on the day of and sending emails. I don't have those with me. I think what Mr. Short is saying, and if he's not saying it, I'll say it, that we really need some time to kind of get all that together.
All right, y'all.
Yeah.
When I met with y'all, when was that? Friday, a week and a half ago? And said, okay, here's how we're going to move forward. And then gave y'all 10 days or so to, before we had our Tuesday, hey, we're doing motions now, and then we're going to move to evidence. Y'all should have used that 10 days to be doing this because we literally talked at that time about we're going to need to go back through some of Mr. Copeland's evidence, and we're certainly going to have to reach what hadn't been reached before. So I know I can't reverse this all back to 10 or 11 or 12 days ago and have y'all then make better use of your time up until now, but y'all, that's what I meant when I said we're going to be doing the evidence this week. So y'all may have a really long night tonight. I do not want tomorrow to be as unproductive as today. And yes, it will help when you have transcripts. And so to the extent I can, will get transcripts out to you as I get them. But with regard to discussions y'all were already having amongst each other, it wasn't that long ago. So.
Seems like it was.
Okay. All right. So how about another witness? If we can't work on Mr. Copeland right now, is there some other witness that we know is going to also have a lot of evidence that is going to be contentious?
Mr. Zachary. Sorry, Mr. Zachary.
Your Honor, Mr. Zachary, there are other witnesses.
Okay.
We've not gone over. Well, we have turned over the statements that Mr. Zachary has made.
All right.
The belief that we intend, if necessary, to use for impeachment purposes.
Okay.
There have been no motions in limine regarding any portions of those statements, as we don't know what, Mr. Zachary has not yet testified. And, we would hope that he be truthful and consistent, but we don't know what he's gonna do.
Okay. So for a whole lot of this, I mean, y'all can't really, let's assume that he testifies. Let's assume for everybody who there might be impeachment or other evidentially challenging evidence out there, that they are going to testify in a way that is going to force y'all or permit y'all to use whatever it is. And then the other party assume, well, let me look at all of this is going to come in if I don't object. What do I think I have a legitimate objection to? And then bring that to me. And I know it'll all be hypothetical right now, but that's what motions in limine are. As to evidentiary issues we think are likely to come up at trial. And then we will go ahead and hash those out. So yes, obviously it's a contingent ruling, but if y'all as the defense have Mr. Zachary's statements and have taken a look at them and know what you think is going to be potentially objectionable, if y'all want to give me those statements, make those objections, I'll hear a response, and then we can try to get through that. That would be great.
And would the court, is the court asking for a copy of each of his statements? Because we can't provide that.
Yeah, because I mean, I'm going to need those if I'm going to make rulings. So yes. And I know in this day and age, almost everything is a video statement. I also know that for Mr. Copeland, when y'all were litigating the evidentiary issues, you had transcripts available, and that would be immensely helpful. It is a whole lot faster because a lot of the statements aren't going to be anything anybody has an issue with, or you're going to have agreed that's not relevant, it's going out. If you can say that's on page 7 lines, whatever, I can go right to that instead of listening through 5 minutes of that before I get to page 7. So I would love transcripts to the extent we have them. And then of course, if in court, I need to, for a particular reason, watch and listen to the video that is the relevant, cogent part, I of course will. But as to, a 5-hour video when there are 20 minutes that are really at issue, if we can hone in on the 20 minutes via a transcript, that would be ideal. Okay, so is anybody ready to go on Mr. Zachary? Anybody? Does everybody have Mr. Zachary's statements?
Yes.
Okay.
That's fine. I'll take the hit here.
They do keep sending you up here to be the one.
That's okay. I'll take the hit. So there are thousands and thousands of pages, and probably thousands of pages of transcripts. So we have a digital copy. I'm sure someone has the full discovery here, but we all have printed out copies of his statements. I know my copy.
But y'all are all old like me, and you like paper.
And because we have our notes on the paper too, and so
Yeah.
I didn't know that Zachary's statements were going to be on the agenda for today, so
Yeah.
I didn't bring the transcripts with all my notes.
I mean, they shouldn't have been on the agenda because Kenneth Copeland was the agenda today, but
Understood.
okay, yeah, I hear you. You're not ready, but you can be ready soon. So when you say thousands of pages, do you mean period or thousands of pages for Mr. Zachary?
Mr. Zachary, to my recollection, has at least 2, I believe maybe 3 statements.
Okay.
And I'm estimating here, I would say a total of about 9 hours of talking.
All right. Has the state determined whether, so I know, like, for example, for Kenneth Copeland's jail calls, I think you had 11, but you said we're only interested in 6 of them. Have y'all done that type of winnowing for Mr. Zachary and the other witnesses that you're going to be getting to soon?
We have been, not entirely winnowed, as the court said, down. We have identified jail calls of particular, not witnesses, but defendants that we intended to use. And when the court says particular witnesses.
I mean, Mr. Zachary is a witness, right?
But I don't believe that we have any jail calls from Quindarius Zachary.
Oh, no, I was just using that as an example of winnowing. I'm not asking about jail calls from Mr. Zachary. I'm asking about whatever you think you might use with Mr. Zachary. If there are 3 statements, for instance, do you intend to use the entirety of all 3 statements? And if not, could you pinpoint for the defense what portions of those statements you intend to use so that if they have an objection to something you're not going to use, they don't even need to look at that because you don't intend to use it. So you can say, here's the portions we think we want to use. And then they can say, only look at those. Here are the objections we have.
Yes, I can do that. I have not broken it apart.
Okay.
Segment scientific.
Okay.
As I wasn't yet.
At him. I don't know when he's going to come in, but all right. So as a part of all of the work y'all are going to be doing before the 5th, That's going to be part of what you need to do.
And not just for him, just so that.
No, yeah, for everybody, for your next 30 witnesses, and then for your next 30 after that.
And so if, not trying to tell the court how to use the court's time.
No shade.
During.
I'm open to suggestions since what I've come up with so far isn't working.
What we can do as a prosecution team, over the next however amount of time the court wishes to allow us is to identify with respect to each of the witnesses that are co-conspirators. I know that there are several. We can, and that it will be coming up in the next batch of 30 witnesses. So we can identify, just to the court and the defense, those people, and begin looking at the portions of their statements, their respective statements, that we would anticipate needing to use as opposed to using the whole thing.
Okay.
And so we should be able, over whatever amount of time the court gives us from here forward today, to go through and come back today with a chunk of statements for each of those people.
Okay.
If not all of them.
Okay. I like what I'm hearing there, that by the end of today, she have done that for all of them. Yes, I like that. Yes.
I said it, so
You did say it.
You know, there we go. But I overshot.
You might have overshot. All right. Well, hey, if you can even do it for one, that'll give us something to work on. And I thought you said you could do that before the end of today. Okay. So anyone, are we ready on anything right now?
It's not anything.
It's not anything we can go forward with, but Judge Glanville had given me, and on behalf of Mr. Nichols, a continuing objection to the admission of any of these statements, in that they have absolutely nothing to do with Mr. Nichols. So I have a continuing objection to the admission of these statements.
All right.
I have a continuing objection, which has been preserved by Judge Glanville, with regard to both the alleged co-conspirators exceptions and any of the contained so-called statements that were made by Mr. Copeland or the other alleged witnesses that the state has called. Last year, we had motions pending with regard to 801 D2E issues, co-conspirator statements issues. The court indicated that, well, it required the state to provide to the defense all of the 801 D2E statements that the state contended it would seek to admit during the course of the trial.
Okay.
That notice was filed on or about by the state on or about, excuse me, November 3rd of last year, obviously. Couldn't be this year yet, although it feels like it. That state's supplement to state's motion to introduce co-conspirator statements and notice of intent to introduce the same. They only noticed three statements. So anything else that they do now after a year, after 19 months, after a specific motion, after specific requests by every single defendant so that we could hash this out. A year ago, they gave us three. So I'm going to object to any other alleged co-conspirator statements that the state seeks to admit under 801 D2E.
Okay, understood.
So I want to get that on the record. And finally, this is prejudicial misjoinder. There's such a spillover effect as to Mr. Nichols. I had an ongoing motion to sever.
Right.
That I want to reallege and reaffirm.
And Mr. Nichols is charged with count 1, the gang count.
Yes, that's correct.
Okay. Do you want to, I think I invited you previously to, but if not, invite you now to provide me a proposed 105 limiting instruction, and I'll take that under consideration.
Sure.
And I'll do that I know that all 6 of the defendants here are charged in count 1, the RICO count. And then other than that, there seem to be sort of 8 or so independent, or not independent, but different acts or sets of acts that some people are charged with 1 or 2, some people are, charged with another set. And yeah, I mean, the people that are not charged with Mr. Thomas's murder might want some sort of instruction that says, other than the gang count, other than the RICO count, this doesn't go to this defendant. So I'm happy to consider some instruction if y'all want to provide me something to consider.
I will provide you with that. Whether you ultimately do that or not,
I don't know. I'll hear from both sides.
Yeah. It's what we've been arguing about the whole time and what I've preserved going forward.
Sure.
All right. So we'll get you that as soon as possible.
Okay. Now, as to the first point you raised, that only 3 statements were identified in the November notice filing by the state as co-conspirator statements that the state had identified as intending to admit. But does the state have more than that now? And if so, tell me why those should come in despite not being included in the November notice.
So, Your Honor, the November notice of 2022.
2022?
We provided 2 801D2E notices.
Okay, so is one of them November 3rd of 2023 as?
Yes.
Okay.
Yes.
And then you're saying there's another one?
Yes, that's November, that was filed on November 30th of 2022.
Okay. And give me a second, Laura.
Thank you, Judge. In the 2022 notice, we stated that the state will establish the ongoing conspiracy of the YSL Criminal Street Gang Act trial, and any statements made between co-conspirators in the YSL Criminal Street Gang conspiracy that were made in furtherance of the conspiracy are admissible, and we request the court grant the state's motion to permit these admissible statements at trial. What we've seen come up, for instance, during jail recordings, there are persons who are not indicted under this indictment as a co-conspirator that make statements to either a witness or a defendant currently on trial, or in the presence of a defendant currently on trial, that the defense has alleged the statements are therefore inadmissible, despite the fact that they come within the context of a jail recording that arguably is admissible, that the statements of a particular party are not admissible. Instances like that, we argue, are instances that involve co-conspirator statements.
Okay, so not arguing broadly, conceptually, but arguing as to specific statements. What notice does the defense have of specific statements that are not included in the November 3rd, 2023 notice? Okay. Because it's one thing to say broadly, hey, if there are co-conspirator statements, we intend to use them. It's another to say, and here are the ones we intend to use. And if the court had ordered, you need to tell the defense which of these you intend to use, then it's time to get down to specifics.
Yes, Your Honor. So in this particular notice, we did provide.
Sorry, when you say in this particular notice, which notice?
The November 6th, 2023 notice.
Okay. November 6th. November 3rd?
It's just, he said it wrong.
It's filed. November, okay. You provided notice of 3 different statements.
Right. 3
right?
specific ones.
Okay.
Yes.
Right?
Yes.
All right. So my question is, are there other statements besides those 3 that you believe are admissible in the trial of this case as to any witness?
There are. Just one moment.
All right.
And so that we are clear, because there's a difference of opinion. So does the court mean out of all of the jail recordings, out of all of the wiretap recordings, out of any recording that we had, which of those contain arguably co-conspirator statements?
Yes.
There are many. There are many that are included in the.
All right. I have yet to find the notice that y'all are talking about.
The November 6th one? We can send it to the court.
There are a lot of filings.
We can
in
send
this
it to the court.
case, but Ms. Persifield has saved it for me somewhere, but there are already a lot of things in our file also. So.
We'll send it to the court and to counsel for defense.
Laura, what's it called? Where do I find it? Is emailing it to me because I need lots of assistance. Thank you, Laura. And so was there an order at some point or a direction from the judge to tell the defense which statements she believed to be co-conspirator statements that led to this supplement?
Yes.
Yes. Okay.
I'm looking for.
Okay. I mean, if there was, that's all I need to know. So yes. So, okay. Now tell me what other statements you believe to be co-conspirator statements and why they should come in now when you were ordered many, many months ago to tell the defense what they were.
They are included as part of the jail calls and the wiretap.
Okay, so they have them.
Yes.
They just haven't been identified as, hey, we think this is a co-conspirator statement. We intend to use it.
Yes.
Okay, well. Sure. Well, I mean, I shouldn't say sure. Sure, you can try to, whether you're successful or not, I don't know.
I understood. So when they say they've been provided, they have not been identified in any way, shape, or form. There are thousands of jail calls involving dozens of people.
Yeah.
There are about 3,000.
I think you've said enough. I understand. Them provided in discovery, not identified as here are what we believe to be co-conspirator statements. Thank you. That was kind of what I thought when she said you have them in discovery. All right. So I would imagine that the discovery in this case is beyond voluminous And at some point in a trial in this day and age, you know how it's supposed to not be trial by ambush anymore? It's supposed to not be trial by ambush. And I'm not saying you're trying to ambush, but at least as of now, really well before now, you should have identified. I think this is a co-conspirator statement. And honestly, you should have identified out of the God knows how many rooms full of boxes of discovery, here's what we're actually going to use. So to the extent you haven't done that, I've already told you you're going to be doing that by telling us very specifically as to each witness, here's the evidence I intend to use. But that's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then tonight look at it and say, here's why it's not. Okay? And for anything that you don't know of right now, you need to go home tonight and huddle together and figure out what else there might be. And I will consider whether I'm going to let that in or not. And then if I do, potentially, we'll have to hear as to each of the alleged co-conspirators why it is that you either have or can establish through admissible evidence that they are in fact a co-conspirator, or not in fact. That'll be for the jury to determine, but there's a preponderance from which I can determine. Okay? All right, so who do you know of right now?
Not only just they ill prepared, they're also not efficient at all.
Okay.
They're not efficient.
She said, give me 1 second. But yeah, I mean, I know it's a big courtroom and there are a lot of us, so we all need to try to remember to speak into the mics. So maybe the state can, and you're pretty loud, Miss Love, but maybe pull that mic down so it's a little closer to all of y'all.
This is ridiculous.
And so that the court knows what I'm doing, I overheated. And so I had to wait.
By which you mean your laptop overheated?
I do mean my laptop. And I was
because I've told you all not to overheat anymore.
So that's what's
okay
happening.
This judge thinks this is a game. This judge thinks this is a game, man. Like this is so. This case again. I'm 100% agreement with Max.
Sure. Could I just briefly address a side issue?
Sure.
When we met for the status conference,
yes.
I believe Mr. Harvey asked you if you would support us when other judges try to drag us in.
I recall that. And you know what? Immediately thereafter, that very night, a federal judge reached out to me and said, oh, I'd like Mr. Harvey for trial. And I said, no, you can't have him. So
thank you so much.
Yeah.
Mm-hmm. But one thing that wasn't clear, or maybe I misunderstood. You talked about when we say take a 1 week break, that if someone wants to call you in for motions, perhaps they can do that. Mm-hmm. So you were referencing that week last week where we were out and why we weren't working to prepare for this.
Right.
I was being called into court all over the state of Georgia.
Sure.
Just because, and maybe that was my fault because I wasn't clear whether you would support us if I told those judges, no, I'm in trial. Because we did have a lot of preparation to do for this week. But unfortunately, I was hauled over all over the state.
Right, and we didn't really talk about that.
Yeah, are you going to cover us for that as well so that we can work on this trial during those breaks?
Because, we may just have to decide that on a break by break kind of thing. Because I, for the last 19 months, have been one of those judges wanting several of you in court for cases pending before me on my other docket. I don't want to blanket say anytime we're not here working on the case, I'm still going to protect y'all, as it were. And frankly, I'm sure that all of y'all would like some time to be able to go represent your other clients in court as well.
Absolutely, Your Honor.
So, why don't we take that up kind of as we need to?
Okay.
And if we are not in court, I hope that we will get into a rhythm if this case proceeds to continuation of trial, where we can have enough done that we can say go Monday through Thursday hard and take Fridays off, or take Friday mornings for motions and Friday afternoons off or something, but like a schedule so that y'all know if you are not prepping for the main witness in the case the next morning, that you can go to court and do some of your other representation.
That would be wonderful, Your Honor.
Yeah.
At least speaking for,
But
for myself.
let's raise it with me when you need to, but
Okay.
I can't give you a blanket answer right
Okay,
now.
thank you.
All right.
Everybody's still waiting on this love. I agree with you, D. Pill. A hot mess indeed. This case is not RICO at all. It's just some street beef. Some Negroes had a little straightening out in the street. And that's it. The gang-related charges, I could understand. But a RICO charge? No. This is nowhere near RICO. Nowhere near it. I'm wondering why she's not ruling on the mistrial.
How long are you going to need? 2 minutes, 10 minutes, 1 minute? Okay.
I'm about to say this with an airhead. Yeah. You talking about the judge laughing like that? Yeah, that's for real. I mean, she laughed a lot like Kamala. Remember Kamala Harris was like, "What do you think you fell out of a coconut tree?" You exist in the context in which all people what? What? Exactly.
Your Honor, we're going to allow Mr. Atkins to stand up and give to the court the calls that we have identified within the wiretap that contain co-conspirator statements.
Okay.
One of the wiretaps.
One of the wiretaps.
One of the wiretaps.
And Your Honor, this wiretap is it's a 6,000 page PDF where you can open up audio links. It has the date, the time.
Okay.
90% of them have what they call reference numbers, where while they're watching the wiretap, they'll give it its own 4-digit identifier.
Okay.
Every now and then, the reference number will just say 0. I don't know why. So I think what makes the most sense for purposes of I wanted for the defense to know where this specific audio is. I'm going to give, for most of these, I have the reference number, the date, the time, and sometimes I also have the PDF page on that document. So that's how I'm going to reference it for all parties to speak off the same sheet of music.
Okay. Give me a ballpark before you do that of how many there are.
Yes, Your Honor. Let me count these up.
Ballpark. 5, 20, 100.
More, they will be closer to 50 to 100.
Okay. So instead of standing there and reading them all, do you have them in writing?
I do. What I can do is take, a lot of these have notes like next to them of things that stood out. And so what I can do is create a document that has the date, time, reference number.
I would think that would be easier for everybody than making sure they write it all down correctly. Tell me this, what witness is this a wiretap of?
So, Your Honor, there's 2 wiretaps. The specific one I was going to start with is Demekion Garlington, who is a severed co-defendant.
Right. Okay.
And I believe almost the entirety of these wiretaps will come in through Detective Viverito, Atlanta Police Department gang detective, who I think is probably ballpark 50 plus witnesses down the road.
Okay.
What?
Okay. All right. So
This
there are
is
going to be
crazy.
a series of alleged co-conspirator statements that are in the wiretap of Garlington. I think I would imagine that the state could speak to me right now about what it is that you will use to establish that Garlington is a co-conspirator. You, Mr. Atkins, will put together the list of all of the details, and you will email that to all of the defense attorneys and the court today.
Yes, Your Honor.
And we can maybe do the litigation of that, maybe that week in August. So I will need at least the portion of the statements that is at issue as well.
Yes, Your Honor.
Okay, so that is one set of co-conspirator statements. You mentioned another wiretap of someone else.
Correct. Of Mr. Sumlin,
And
who is also, he has pled guilty, but he was one of
Okay.
the 28 indicted defendants in this.
So you've done your proffer for that one. That one will be easy if he pled guilty.
Yes, Your Honor. Yes, Your
All
Honor.
right, Sumlin. And there are, you can do the same for him.
Correct.
Okay,
And
perfect.
he has less, it's hard for me to ballpark the.
That's
number for
fine.
him,
I just was like, if it's two, you can read them out, but if it's some huge chain, then it's easier to just give them in writing.
Yes, Your Honor.
Okay, all right. So that is two further potential co-conspirators who have statements we will need to litigate. Whom else?
Your Honor, we have an additional co-conspirator statement from Mr. Copeland, a jail call.
Okay.
That's a part of the 5
jail calls.
About a portion of the 5 jail calls.
All right, hang on. Is that a surprise to anybody? Do I need to do a back and forth about whether it's fair for that to come in? Okay, that was part of the notice, so that one's good.
I don't think it was part of the notice, but
they don't think that was part of the notice, but they're willing for y'all to say that's good.
But there was just a portion of that call that the defense objected to, but we can talk about that.
Okay, and all right, but y'all have already been litigating that, so I'm going to call that one good in terms of notice. Whom else? All right, question. So I'm looking at this November 2023 notice, and at this stage, when it was filed, they're talking about witness A. Y'all all know who is referred to in each of those at this point? Okay.
Yes.
Okay.
We filed a supplement that wasn't filed. We gave to them.
Okay.
Witness A.
All right. All right. Can you provide to this judge whatever that supplement was so that I know?
Yes.
Thank you. Do y'all, deputies, you know whether lunch is here yet for the, okay, why don't we break for lunch? Be back at, how long, practically speaking, do y'all actually need to get everybody fed and restroom breaks and back? Hour and 15? Okay, let's break until 1:15.
This is a quick question.
Yep.
I can't, I'm having a hard time finding a statute on recusal that says you're not allowed to say the truth of what happened to the judge. I can't find that.
Okay.
I'll look for that. I'll look for that.
During lunch.
That I referenced where it said that you can't use.
Okay.
Matter of.
That'll be great.
Thank you.
Thank you. All right, we're in recess. Let's say till 1:20 since we've already eaten up like 5 minutes.
All right. What do you all think, man, about this whole situation? Trying to gather.
When the court had asked me earlier
Uh-oh.
whether in all of the jail calls, all of the wiretaps, all of the recordings.
Yes, at this stage of the game, we need to give notice to the defense of every potential co-conspirator statement. And if in the afternoon you can do essentially what Mr. Atkins just did, it's going to be this set of statements, and we'll give you the details of where to find it later. That's fine. But yeah, it's going to be this witness, that witness, and the other witness in these statements as to each of them. Yes, because A, they need to know at this point, and B, we need to know what we need to litigate at this point. Okay. So yes, thank you. All right, in recess.
All right. I think the recess is real now. So Sheila says I think a mistrial is necessary is what I think. Absolutely. I'm surprised that she didn't even attack that first yet. I thought that would have been priority number one. Is taking care of the mistrial motions. Since she did the bond motions yesterday and just denied all the bonds, I would have thought that she would have done something, a little bit more efficient. He says the state is not prepared. They had plenty of time to get their ducks in a row. Absolutely. I want to look at something. I gathered some information since we're on a break. I gathered some information concerning the R. Kelly situation. Let me see here. Let me take a look at my stash. And so let's see. There was recently R. Kelly had asked for a petition for writ. Hold on, give me 1 second. Certiorari. This right here, check this out. This is a petition for the Supreme Court to review a lower court's decision on his case. Let me check it out real quick here. I'm going to see if there's anything in here. I'm telling you, I'll be having so much information, man. I have so much information. You know what? I don't know if I want to read. See, the thing about it is reading this is very, very triggering for a lot of people. I don't know if I should read this. Let me look at this first real quick here. It's it has some details of let's see here. I'm not sure if I'm going to read this. But the whole point of the petition is he wants the Supreme Court to look at a ruling that a lower court made in reference to his case. So we're not going to. I will talk about that. I'll probably make a video about it. And get some details from that. For those of you that came in a little bit late, let's go back to this document that Douglas Weinstein, which is Diamante Kendrick's attorney, wrote. And just to inform everyone that came in late, this document has Exhibit A. Exhibit. And Exhibit A, for those of you that came in late, is another ex parte meeting that happened on June 7th, which is the day that Lil Woody was arrested. So there was another ex parte meeting. And in this particular ex parte meeting, it was Glanville, Hilton, and Love in chambers talking badly about Melnick, Steele, and Max Sharp, and pretty much the entire defense implying that there was some type of influence or some type of outside agitators is what they called him, that was trying to get Woody not to testify. However, Woody had already stated that he was going to invoke his fifth. He said that to his lawyer after his lawyer found out that he had been talking to the state behind his back in representation. And the state is acting like, oh, it's nothing. So they start getting to the ear of Glanville, and Glanville's like, oh, yeah, I've been seeing this. I've been seeing certain things in the courtroom that's causing a little bit of influence on Woody, and trying to imply that the defense has some type of co-conspirator type of thing with the defense, when they're really just representing the defense. Here's something that we could take a look at in the meantime, in between time. It's Brian Steele's opening statement, which is something I haven't seen before. But there was an ex parte on June 7th, the day that Woody was supposed to testify, the day that he was sworn in, and testified after pretty much being, again, coerced. And the immunity was forced upon him. He never even really received the use immunity offer. It was just filed by Fonnie Willis. Shout out to Chill, the #1 mod in the building. I appreciate you. That I have to go and we'll catch the replay. Have a great rest of your day, everyone. Awesome. So this is something that is totally, totally crazy. Is the fact that you have a lawyer, a judge, two prosecutors, and a judge having gossipy type of conversation concerning the defense. And the you know what's so funny about it is the fact that they're trying to say the defense is co-conspirators. The defense counsel is co-conspirators with their defendants, but these three over here is having a ex parte conversation, and Judge Glanville is talking about, yeah, you know what? I saw the same thing you saw. I saw some influence. I saw this. I saw that. And so this is something that is really, really bothersome. Okay, is the fact that this judge right here is not understanding what's going on. There is so much to unpack in this case. Bruce Harvey made a great argument yesterday by saying it is impossible for you to be able to get caught up efficiently. And her thing is this, well, since Glanville is recused, everything about Glanville is done away with. No, that's not the case. You have details that are now a part of this case that causes this case to be now, as the words of Scott McAfee, an order of mendacity. In other words, the waters are so muddy, you can't come out clean. And so this is a problem. This is a total problem. And so I don't think that this judge is taking this seriously. I don't think that this judge is being particularly focused when it comes to certain things. She's so concerned about making sure that nobody running in and out the courtroom. She's so concerned about making sure you don't eat in the courtroom. She's concerned about this, that, and the third. And I understand she's trying to gather information, but all the information you're trying to gather, trust me, it's so much information. It's going to be overwhelming. That man said that there's about 6,000 pages of a wiretap, and there's about 50 to 100 co-conspirator statements in the 6,000 pages. And you want them to have this by when? You want them to identify those things by when they supposed to have done that way ahead of time. They have had this case for 19 months. 19 months of this case. And you mean to tell me they can't give you not one identified co-conspirator statement? Stop it. Just stop playing with me. Just stop playing with me. Stop playing with me. Okay? Stop playing with me. It's ridiculous. It makes absolutely no sense. You've had 19 months with this case. You haven't given us the identification of any co-conspirator statements at all. You haven't been able to give the judge any type of, you've been asking the judge for the defense to give you evidence that they don't need to give you. One of the things they try to do, again, for the fourth time, is try to get reciprocal evidence from the defense, even though the defense is not case in chief at this point. That's another thing. She hasn't addressed up mistrial motions. If I'm gonna be honest with you, if all of this is going on right now and she decides to do a mistrial, I'm gonna be so upset. You could have just led with that. You got people doing things and making it look like y'all working on something. If she grants a mistrial with no retrial, I'm telling you, I'm probably gonna lose it. It'll be good for the defense, but I'm probably going to lose it because don't take us through all this stuff knowing that it is so much damage done. It is so much brokenness in this case that you have no way of mending it back together. And you trying to come in like you Wonder Woman or Supergirl or Superwoman as if you're going to bring this back together, like you're going to single-handedly restore the faith in the judicial system in Fulton County. No, we already know you terrible. We know already. You in Atlanta, you in Fulton, I already know you all are like, you know what? This is a trip. I don't even want to get so much as a jaywalking ticket in in Atlanta because it's going to be a problem. You can't trust the judicial system down there. Now just imagine how it is in all the states. The system itself is broken. So there's no way of fixing this. And what your boy Harvey Doug Harvey said is that, man, this is like trying to renovate an old house. Let me just read this for those that came in a little bit behind. Let's read this. It says here, Judge Glanville making outrageous allegations against members of the defense teams in the present case. But I think it does in some way outside agitators. The third ground argued in Kendrick's motion for mistrial is that Kendrick's due process rights were violated relating to the 14th Amendment, due process violation relating in part to Chief Judge Glanville wrongly coercing Copeland to testify. This is for those of you that came in a little bit behind. This is the actual motion. And shout out to Drea, once again, another great mod, who sent the link to this motion that was filed 7:15 this morning by Doug Weinstein after they got the transcript of the ex parte meeting on June the 7th. Not the ex parte motion that we all read. I'm talking about this is June 7th. This is the day that Woody comes to court. And look at what Doug Weinstein says. I just want to go ahead and double back here. Further evidence of the state and Judge Glanville's violation of Kendrick's due process rights has come to light. Yesterday, after court, Kendrick received a rough transcript. That transcript is in this exhibit A, of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7th. Friday, June 7th was another ex parte meeting. Remember yesterday it said how many ex parte meetings were there, blah, 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 blah. Are there any other ex parte meetings? Yes. The one on Friday, June 7th. That's the same day that Woody's invoked the Fifth Amendment on the witness stand. Okay. And it says here that the rough transcript was helpfully provided by this court to defense counsel. A reading of the rough draft highlights that which has been obvious to all observers, except for, of course, Kendrick's counsel, for the past 19 months. What has it revealed? Judge Glanville has been willfully biased and acting as a member of the prosecution team since the inception of this case. Kendrick's counsel takes no pleasure in alerting this honorable court to this situation, but client obligations require it. Due process requires a fair trial. It is not fair. It is not a fair trial when an ex parte meeting, he said Glanville, Love, and Hilton was gossiping like yentas. Over 13 pages of a transcript about attorney Sharp, Melnick, and Steele. It's not fair when the meeting is assassinating the character of Attorney Melnick and attacking his integrity, alleging that he is not acting in the best interest of his client. It's not fair when an ex parte meeting has Glanville, Love, and Hilton attack Attorney Bumpus for allegedly hugging Kendrick and stating that she is incapable of representing Copeland just because she gave Thug and Kendrick a hug. Hello, Caleb Bumpus knows these people. Caleb Bumpus was Woody's attorney before Melnick was. And Melnick and the very first live that Miss Bumpus ever did was her stating that was Melnick stating that Attorney Bumpus was the lawyer before he got there. But they have been, I guess, doing like a dual representation over the last few years of Woody. As a matter of fact, like we stated before, the actual interrogation video that came leaked out where he was singing like a bird, the detective mentions Mr. Melnick in the interrogation room, mentions him. That was back in 2021, I believe, 21, 22. So he's been having representation for a long time. It's not a fair trial when an ex parte meeting has Love lying to Glanville about an email she received from Attorney Melnick. Again, this is not a fair trial when an ex parte meeting has Glanville starts talking about outside agitators. There it is right there. Proof. Outside agitators, according to the transcript. And this is the question. How many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? How many violations do we have to have before you make this a mistrial? You know, how many times does my client have to sit through such BS before you say, hey, this constitutes a mistrial? A judge is having ex parte meetings and saying things to go against the defense, looking like they're on the same team. When you are a judge, you are not supposed to look like you're on the same team with anyone. You are supposed to be a referee. A referee just calls the fouls. And just like in basketball, you call the foul, you say if it's flagrant, you say if it's a flagrant 2. If something goes out of bounds, if someone hit the ball out of bounds, you make sure that the other team get the ball. You be fair. Nothing about this is fair. Nothing about this is fair. Since we're on break, in the court, they're going to come back at 1:15, 1:20. Let's go ahead and look at YSL Steel. Let's highlight Steel. Remember, we did the Silver Fox, right? The Silver Fox, we expressed and we saw his opening statement, which was brilliant, textbook. Now we're going to look at YSL Steel. And let's enjoy this for a little bit before they come back from break. But that motion that Weinstein presented I think is absolutely brilliant, straight to the point. And I believe that she needs to hurry up and rule these mistrials, man, for real, because this is absolutely insane what's going on. Let's go ahead and look at YSL Steel. All right, let's go.
That's here in Southeast Atlanta. It's a very small 3-bedroom apartment. He lived with his 4 brothers in one of the small bedrooms. His 6 sisters lived in the other small bedroom, and his mother lived in her small bedroom. In the wintertime, it was freezing. In the summertime, it was scorching, because there was not that much money to go around to pay for utilities. The refrigerator and the cabinets hardly ever had any healthy food, and sometimes no food at all. In order to have the appearance of being able to wear different clothing, Jeffrey would share clothing with his brothers and sisters, neighbors, and friends in the community. And although the clothing was oftentimes dirty, at least it gave the appearance that he can have a different look from the day before. When Jeffrey would exit into the community, most homes' windows were boarded up. There were burglar bars on every entrance. Litter. It was not uncommon to find shell casings and human blood remains from the shootings that occurred. There was glass on the ground from the broken window of the cars. The cars are gone. In this environment of severe poverty, severe crime, Jeffrey developed two deep, embedded beliefs about our criminal justice system. The first one is that it is not justice. Our criminal justice system was not just, at least for people that he saw. Jeffrey would see over and over again people in the neighborhood who were known to be the liars. These are the people that would lie to their kids, lie to their mothers, lie to their brothers and sisters, and then somehow those people would be used by prosecutors, allowed to come before judges. And they would have reduced charges, reduced prison sentences, reduced probationary sentences, no charges at all, on their oath that they come in the courtroom to tell the God's honest truth.
Your Honor,
You have an objection, ma'am?
I have an objection.
What's your basis?
Your Honor, I'd rather approach and not speak it out loud in front of the jury. It will take 1 second.
All right.
Thank you.
If I put your list and device on, please. Hold on.
I think love was being petty. What was there to object during that particular part of the opening statement? Shout out to Callie in the building. About to get some coffee. That's what's up.
Whoever's got their mic, turn it really loud, turn it down. Okay?
This was the opening statement of YSL Trial, man. We about to check them out. I think right there he knew like this is going to be a tough trial. Absolutely, facts. This is a fact. Love to have lied to the jurors, and we called her out on it. Alicia Fee said, I'm having coffee and I'm having lunch. All right. Abundance said, it's 9:32 at Cali.
Jeffrey learned that these liars, these snitches, these rats, they would come into the courtroom, take a witness stand to tell the God's honest truth. They were still the same liars. And they would testify against people accused of crimes. Jeffrey thinks that the entire justice system is corrupt. It should be blown up. And everybody who feeds into that are awful people, stealing lives away from others. The next abiding belief that Jeffrey had growing up is his despise for the police. He would see people walking on the streets. This could be an adult, teenager, a child. Wearing their backpacks, holding a football, bouncing a basketball, and the police just swarm in. They're aggressive. They search the backpack. They throw the football over the house. They kick the basketball down the road. It got to the point when people saw the police coming, they just ran. It's different experiences in different parts of America. It's different experiences in different parts of Atlanta. Jeffrey would be driving with his sister, youngest sister Dora. They're about a year apart. Dora is younger than Jeffrey. She's the youngest of 11 children of Jeffrey's mother. Jeffrey's the second youngest. He's the youngest young man. Those two, Dora and Jeffrey, are the same father. None of the other 11 children of Jeffrey's mother share the same father. And Dora and Jeffrey would be driven, get pizza by their dad, and constantly. The car would be stopped for a window tint violation, a failure to maintain a lane, failure to use a turn signal, illegal left turn. His father would be handcuffed and sat on the curb, Jeffrey and Dora on the other side of the curb, the police rummaging through the car, saying, if we find anything, these kids are going to DFACS custody. That's how he grew up. But what really solidified Jeffrey's distrust for the police happened 3 days before his 9/11 year-old birthday. Jeffrey's born on August 16th of 1991. We are now August 13th of 2000. Jeffrey's older brother, they called him Beanie. He was 20 years of age, 11 years older than Jeffrey. He's shot in the chest. He collapses outside, not far from Jeffrey's apartment. The neighborhood comes out. Jeffrey and his family come out. They're praying over Beanie. It's going to be okay. There's help on the way. 911 was called. And what seemed forever, when the police finally did arrive, they didn't go immediately to Beanie. They had to push back the crowd. Jeffrey's mother was hysterical. She was screaming for her child to survive. The police handcuffed Jeffrey's mother, put her on the ground. And when they finally went to Beanie, put a sheet over his face, Beanie was dead to the police, even though his chest was still going up and down, he was still breathing. The Jonesboro South housing projects were closed by the city of Atlanta in the year 2007. Jeffrey's now 16 years of age. His family was displaced. They were scattered. Most of them, not all of them, reunited and now living in the Cleveland Avenue area. Jeffrey was not educated in his home about go to university, work as a flight attendant for Delta. Somebody would loan you money so you could start a business. Jeffrey believed that the only two ways he can break the generational hopelessness and despair for his family, himself, and he wanted to break it for as many people as he could who were in this struggle, was to be a professional athlete or an accomplished musical artist. Jeffrey chose the latter. And from that day forward, every week, every month, every year to this day, Jeffrey practices to make himself a better musical artist. In Jeffrey's neighborhood, rap, it's a subset of hip hop. Gangster rap is a subset of rap. That was the most popular music at that time. So Jeffrey sought to find out how can he accomplish his mission to be a successful rapper. So he had the internet. They were poor, but they had phones with the internet. So he would Google and look up and get on social media every accomplished rap artist and see what made them special. And Jeffrey would listen to the beat after beat after beat. These are billions of musical chords that he listened to. And he tried and he forced himself to be able to speak fast within the beat and rhyme words. Jeffrey can't sit there and write out the words. He doesn't spell well. But he can listen and learn and look up what words mean, or just make up words to put them into the beat. And Jeffrey studied two rap artists particularly. He idolized a gentleman named Dwayne Carter. His performing name is Little Wayne. Jeffrey also idolized Tupac. And Jeffrey looked at, what is Lil Wayne doing that's making him so successful? Because Lil Wayne is right before Jeffrey. He is born on September 27th of 1982. He's 9 years older than Jeffrey. And Lil Wayne, by the time that Jeffrey came along, has exploded. He is a superstar. And Lil Wayne changed the culture. It was more than just the sound of the music. Now, Jeffrey studied Lil Wayne so much, he sounded like Lil Wayne. You're going to hear witness after witness that Jeffrey sounded just like Lil Wayne. But Jeffrey realized that Lil Wayne had a following, a fan base, and people who dressed like Lil Wayne. It used to be that rappers wore baggy pants, big uniforms from teams. Lil Wayne changed it. He wore proper fitting pants. Lil Wayne tattooed his face. He's the first one. Jeffrey has tattoos on his face. Jeffrey changed the clothing. He took what Lil Wayne did, and Jeffrey wore tight fitting pants. He's the first. He did that because when he would take his ill-fitting clothing from his sisters, they were tight jeans. Jeffrey wore tight necklaces. He wore dresses. He realized in order to become successful and to accomplish his mission of breaking those bonds, he had to capture people's experiences and make it interesting, both musically and creating a brand. He's advertising. Jeffrey was called Little Jeff. His father is Jeffrey Williams Sr. He was called Big Jeff. But Jeffrey is sounding like Lil Wayne. He's trying to emulate Lil Wayne on social media. To call himself Little Jeff and Lil Wayne, he thought that that doesn't sound too. That's a bridge too far. So Jeffrey wanted to have a performing name. So he looked to Tupac. You will learn that in 1983, the incomparable talent Michael Jackson released a song that went around the globe, P.Y.T., Pretty Young Thing. About 13 years later, Tupac is featured on a song with Smooth. And that song is P.Y.T., Playa, P-L-A-Y-A, Young Thugs. And on that song, there's a repeat of words. And this really connected with Jeffrey. It's a black man that not too many understand. That's what Jeffrey felt about people with nice color skin. Jeffrey had interest in women, but he never considered himself a player. A player to Jeffrey was somebody who had the girls kind of coming at them at all times. Jeffrey wasn't like that. Jeffrey was shy. He was really tall and really skinny. He was malnourished. His teeth were rotten. There was no money to go to a dentist. and all the sugar from the candy that he ate to keep substance in his body rot his teeth. So Jeffrey would speak by covering his teeth with his lips, or often speak like this with his hand or his arm over his teeth, because he had low self-esteem. He was made fun of and bullied growing up. So he got rid of the player. That was not going to work for him. But he kept the young thugs. He got rid of the S, and he became a performer, young thug. And from that day forward, he insisted everybody call him Young Thug. On every type of tweet, Facebook, social media of any kind, on any records, he refers to himself as Young Thug. And that fit in to the appearance of the gangster rap, because most people think about a thug as a criminal. But to Jeffrey, thug had a different meaning. Now, some of you read books about Tupac and what it meant to be thug life. Thug life, the hate you give little infants, F's, everyone, meaning discrimination and racism hurts all of us. We teach that to our kids. That was not what thug meant to Jeffrey. Thug meant and means to Jeffrey something very personal. It was his pact that if he could ever make it as a musical artist and help his family, himself, and as many others out of this endless cycle of hopelessness, he would be truly humble under God. That's what thug means. Jeffrey is talented. He worked so hard, he'd outwork everyone. He would stay up all night after night trying to rhyme words, put him to beats. When he had time and the opportunity to go into the studio, he wouldn't leave. He is a prolific creator of music. The neighborhood realized his talent. He was the best rapper in the neighborhood. So Jeffrey was invited to the underage clubs to perform. And he would be the introductory entertainer. He would be able to perform 5 or 10 minutes, $50, get paid $100 sometimes. He's about 17 years old, 2008, 2009. When Jeffrey would leave the establishment, he'd get robbed. And the money was gone. And that money may not be a lot of money to some of you in 2008 or 9, but to Jeffrey, it was food. It was meals for him and his family. The next time Jeffrey went for an event, he did not get armed robbed. There's a man in the community who's a man of influence in the community. He was allegedly the leader of Raise on Cleveland, the supposed gang rock crew. He was supposedly the leader of the Bloods in that area in Cleveland Avenue. His name is Quentin Porter. Goes by Boo or Big Boo. And when Jeffrey comes to make the performance, he's no longer there for 5 or 10 minutes. He is the lead performer. He's going to go last. As the time went on, the neighborhood got behind Jeffrey. The rock crew, the Bloods, the whole neighborhood. They would put up signs on the post, come out tomorrow night. Watch our own young thug perform at this establishment. The place is sold out now. This is no longer 25, 35 people. There are hundreds of people in the club. There are hundreds of people in the parking lot trying to get into the club. There are hundreds of people backing up in the streets, all to see Young Thug. The people who own these establishments are making money. They are attracting customers. Word gets out. Jeffrey's no longer just performing in the area that he grew up in the poverty-stricken area. He's now in Atlanta, South Georgia, Alabama, Florida, South Carolina, North Carolina, Tennessee. He is performing all of the time. By 2011, Jeffrey released his first album. It's entitled, I Came From Nothing. And yes, he speaks about killing 12 and people being shot and drugs and drive-by shootings. This is the environment that he grew up in. These are the people he knew. These are the stories he knew. These are the words that he rhymed. This isn't a ballad or a book. These are phrases in a song. And whatever the listener takes from it, you will learn that's what the song means. This is art. This is freedom of speech in America. As the years go on, 2013, 2014, Jeffrey's now 22, 23. It's unbelievable. He has 3 hit songs that are going around the world. Stoner, Danny Glover, and Lifestyle. He is making music videos professionally. He is working with some of the biggest artists in hip hop. It worked. It's unbelievable. He is not running this criminal street gang in Cleveland Avenue area of Cleveland to gain property, money, or power. Jeffrey Williams did it on will and hard work and determination without anybody's help, except the people from that area that he will not turn his back on. By 2014, to today, you will learn. Jeffrey Williams has been nominated and won and recognized MTV, United Kingdom, American Soul Train Music Awards. He is a Grammy Award winner. XXL Awards, BET Awards, Billboard Music Awards. Every single year since 2014, that's what he has accomplished. He is not sitting there telling people to kill people. He doesn't need their money. Jeffrey's worth tens of millions of dollars. Jeffrey has been a sponsor for Puma, Calvin Klein. He has been featured on the cover of Rolling Stone magazine, GQ magazine, XXL magazine, Paper magazine, Complex magazine, Variety Interview magazine. He is at the top of his craft. Jeffrey is so talented in music, he doesn't only do gangster rap. He does rap, gangster rap. He has hits in country music, popular music or pop music, Latin music, Afro, beats. He's been featured on NPR, Tiny Desk. He's played numerous times on Saturday Night Live, Jimmy Fallon Show. Jeffrey has performed in almost every continent on the earth. He's performed in front of more than 300,000 people that come for him. His social media feed has more than 10 million followers. He's not the cradle. He's trying to pull people out of poverty. Jeffrey has performed with the likes of Rihanna, Ed Sheeran, Sir Elton John, Drake. Everybody in music. And Jeffrey didn't only stay in music. He did fashion. He's an icon in fashion. He has been to Paris, to Spain, all over Europe at the fashion shows. He has his own clothing lines. People are walking around the earth today with Jeffrey's picture tattooed on their calves, on their shoulders. They have his lyrics on their bodies. YSL, when Jeffrey was coming up and making it, Lil Wayne had and repped, talked about Cash Money Records. That's his label. Jeffrey's friends in Cleveland Avenue, they call themselves YSL. Because on the pants, the tight-fitting pants, the women's pants that they're wearing, it says YSL, Yves Saint Laurent. That's where that comes from. Ladies and gentlemen, Jeffrey stands before you, charged with some of the most serious crimes in the state of Georgia. I'd like to go through with you each and every crime that he's charged with in the indictment. The indictment's thick. You're going to have it. At the end of the case, the Honorable Judge Glanville will give it to you. You should read it. It's the charging document. It is critical in the case. There are many counts. Most of them Jeffrey's not charged with. But everybody, there were 28 people who the prosecution, through the grand jury, indicted together. They're all in count one. That's why this is a joint trial, because everyone's in count one. That was the decision of the prosecutors. You will learn that Jeffrey doesn't even know most of the people in this indictment. He doesn't know them. They all know him because everybody in that area knows Jeffrey Williams. He is known as the Michael Jordan of that area. He didn't get out and stay away he tries to come back and give people hope, because he knows what it is to be depressed, hungry, and have nothing going for you. The first count is a RICO conspiracy. And the supposed objective that the prosecution charged is that Jeffrey, along with others, had a meeting in the mind. They had an agreement. They have an agenda together. And that they wanted to preserve and protect and enhance the reputation, the power, the territory of YSL. That's the allegation. Jeffrey hasn't lived in the Cleveland Avenue area in a decade, more. He has homes from Los Angeles to Atlanta. But they charge him with, he wants the reputation, power, territory of the enterprise by obtaining money, weapons, or other property. Jeffrey needs no money from somebody on robbing someone of a car or doing a $30 rent deal or even $100 million, right? He's got his own source of legitimate income. So RICO conspiracy, there are then what's called overt acts. The judge will charge you on the law. But there are 191 overt acts. And those are separate instances that the prosecution said they're going to prove. Most of them don't include Jeffrey. But the ones that do, I'd like to go through with you. And I've broken it up into 3 categories. Because an overt act can be a crime. It doesn't have to be a crime, so I then wrote chats, social media, any type of statement, because the prosecution has been investigating Jeffrey for a decade. They have all of his personal chats. You think you're talking to somebody on Facebook in a personal chat, they have all of his thoughts. They put these in the indictment. The third category are lyrics. So I'd like to go through them with you. First is going to be supposed crimes, and these are the overt acts that you will see that involve Jeffrey. As you can see, Jeffrey has never been convicted of a crime. He stands before you, he's not a convicted felon. He can vote, he can carry a gun, he can be on a jury. But now, these acts are embedded in the indictment. So let's start with the first one. So this is September 9th of 2013. Jeffrey just turned the age of 22. And he's driving in a car, and he gets stopped, of course, for failure to maintain a lane. And the police officer comes up to the car, and Jeffrey doesn't have a license, doesn't have a valid driver's license. So now he's under arrest. Police officer says he sees pills, Xanax pills, 7 of them, on the console. Police officer searches the car, and underneath the front passenger seat, there's no passenger, there's a gun. That weapon comes back stolen from Andrew and Ann Phillips months before. There's no evidence that Jeffrey's involved in that burglary of the Phillips home. There's no evidence Jeffrey ever touched that gun. You're not going to hear any type of DNA, fingerprints. In fact, Jeffrey says, that's not my gun. Police officer wants to know, whose gun is it? Jeffrey's not talking to police. So Jeffrey gets arrested. That case got dismissed. But 10 years ago now, it's an overt act for you to consider. You will learn that this stop was video recorded and audio recorded. But the City of Atlanta Police Department, the District Attorney's Office of Fulton County, I demanded that. They can't find it. So you're going to rely on a report of an officer who doesn't remember this incident. That's it. That's an act in furtherance of the conspiracy. That's the entirety of it, that first overt act. The next one. This is overt act 5 through 7. You may notice that Jeffrey's not even alleged to be in this overt act, but now you're going to hear Jeffrey's supposed involvement. This is 2 days later. It's September 11th, an infamous day in America. It's 2013. Jeffrey was arrested, if you remember, from the last overt act, September 9th, 2013. He made bond. He just got out. Walter Murphy, he grew up with Jeffrey. He's one of the people that would exchange dirty clothing with Jeffrey. You will learn that they would have no money between them. One of them would come across $1. They would split the food that they could buy with that $1 together. Walter Murphy is with a person named Adrian Bean and Fred Plethora. And there is an armed robbery of Mr. Dotson. Gunfire went out. Police are always in this area. So when the gunfire was heard, police respond immediately. Adrian Bean is driving the car. This is a car that he borrowed from a friend. This has nothing to do with Jeffrey. So he commits a crime in someone else's car. Adrian Bean almost kills a police officer, almost runs him over, driving so recklessly, high rate of speed, goes across a neighbor's lawn, over an embankment. The car is now airborne. It goes over, you'll see pictures, goes over a parked police car in a parking lot and slams into the side of a laundromat. The car crashes. Mr. Plethora is shot. Police are firing at the car. Mr. Murphy is shot. Mr. Bean runs away. He's captured. Mr. Bean, you will learn, is told, hey, we believe there was a fourth person in that car. If you make that young thug, we'll go lenient on you. Adrian Bean is in the Fulton County Jail talking with his wife. He said, I should have ran the way Thug ran. He got away. That's recorded anytime an inmate, a person is incarcerated, in a jail. Most of the time, if they're speaking with a pastor, a lawyer, their calls are being recorded. You will learn that Mr. Bean also stated on a recorded call, they gave us a story to tell. Mr. Bean is interviewed 4 days later, September 17th, 2013, by Detective Quinn, City of Atlanta Police Department. Detective Quinn it's a big case because police officers are discharging their weapon. People are getting shot. Detective Quinn interviews Adrian Bean. And Adrian Bean tells him, they talk about this recording. Adrian Bean tells him, I lied to my wife. Everything on those recordings are not true. Jeffrey was never arrested for this. He was never charged for this. He was never prosecuted for this. He's not even in our indictment on Overt Act 5, 6, or 7. But now, we're going to hear from Mr. Bean. That's it for the next one. Somehow that furthered this conspiracy. Jeffrey was not even charged. Next overt act is January 7th of 2015. Now, this is a larger part of our case probably. God forbid, Donovan Thomas is going to be killed 3 days later. It's going to be January 10th of 2015. And in order to understand this rental car, and there's nothing clearly wrong with renting a car, but in order to understand this rental car and then 3 days later, the killing of Donovan Thomas, you have to understand some background. So we're shortly before New Year's of 2015. And there's a man named Kenneth Copeland. He goes by
the Rudy. The Rudy.
And Kenneth Copeland is not friends with Jeffrey Williams. He uses Jeffrey Williams, just like a lot of people. Because Kenneth Copeland wants to be famous and have money. So he reaches on to Jeffrey Williams about a year before that. Well, Kenneth Copeland is a criminal. He is a notorious criminal. In fact, you will learn that he was ranked one of the 10 most violent people in Georgia by the federal prosecutor here in Atlanta. That is Kenneth Copeland.
Wow.
Kenneth Copeland breaks into cars.
The more you know.
He steals the property they're in. Donovan Thomas is the head of a gang called IF, Inglewood Family. Donovan Thomas and Jeffrey are friends. Jeffrey's friends with everybody. It promotes him. And Jeffrey tries to help other people at the same time. Kenneth Copeland breaks into Donovan Thomas's car. And he takes his expensive chain, Donovan Thomas's wallet, his driver's license, and Donovan Thomas's cellular telephone. Donovan Thomas calls his cellular telephone. Kenneth Copeland answers the call on Donovan Thomas's phone. Kenneth Copeland changes his voice, tries to disguise his voice, but Donovan Thomas knows it's Kenneth Copeland. Donovan Thomas has people on the street. And he tells Kenneth Copeland, "You have my stuff. I'm coming to get it back." And Kenneth Copeland says, "Yeah, I'm glad you called me. Because one of my partners had your stuff. I realized it was yours, so I got it for you for safekeeping. No problem." When Donovan Thomas meets with Kenneth Copeland, he doesn't come alone. He comes with two other people, and they display guns. Kenneth Copeland's not alone. He's with his brother. They're really not related, but they call themselves brothers. His name is Demekian Garlington. Demekian Garlington and Kenneth Copeland are like this. They are inseparable. Demekian Garlington and Kenneth Copeland are together.
All right, I'm gonna stop it right there because court is about to be in session. But how about that though, right? How about that? Lil Woody, man. Unbelievable. Unbelievable. That was the opening statement of one Brian Steele. And it's amazing how they did RICO based on some pills and a gun and and all this other stuff. But what he said about Woody was like, wow, he leeches off of Young Thug, right? You know, that's very, very interesting that he labeled him as a leech like that. And the fact that you break into his car, act like you found it for the person that you broke into the car. You act like you found the stuff, and then you want to go back and then say, hey man, I found this for you, man. I kept it for keepsakes or whatever the case may be. And then when they come get it, they know you broke into the car, man. You know, and you try to play it off like you didn't do that, like you didn't do anything. But man, top 10 in Georgia of criminals? I did not know that. See, sometimes you got to go back a little bit and see things from the beginning and be like, oh, no wonder there's a disdain for Woody. So court is about to be in session in a minute. Let's go ahead and pull it up. Very interesting opening statement though by Brian Steele. And Brian Steele was putting a little bit. He was landing on a little thick for Thug, man. He was landing on a little bit too thick. But this is the court is in session. That it says state of Georgia, Constitution, wisdom, justice, and moderation. Mm-hmm. You're right. That right here should be corruption, corruption. Not prepared. Yeah, so interesting opening statement. What did y'all think about the opening statement? That was very interesting. But Abundance, you had me rolling talking about the man talked about Tupac, MJ, and PYT and Slim wearing tight clothes and dresses. Oh man, that was absolutely hilarious. We got one more minute until court starts. Very, very interesting stuff so far when it comes to this particular case, these motions and things of that nature. But as you can see, the state has not been too prepared. They have not even identified co-conspirator statements in the 6,000-page wiretap report, or supposedly. I don't know what the state thought. I don't know what they thought, but you got to be prepared, man. This is your case. This is your case. The burden of proof will rest upon you, so you got to see this case through. But yeah, this is very, very interesting. So far, what do you all think about Judge Whitaker? Do you like? Are you feeling her? Are you not feeling her? I mean, honestly, in my opinion, I got mixed emotions about Judge Whitaker at this point. She likes to cut people off a lot, and she likes to rush the process of getting information out instead of hearing things in a more efficient way. It's very, very telling. Very, very telling. But I don't know. I'm having a little bit of mixed emotion when it comes to Judge Whitaker. So, what do you all think about her so far? Let me know in the chat what y'all think. It's amazing too how, you know, when it comes to this particular case and this particular part of the case, the motion hearings and things like that. It's amazing how she has not addressed the motion for mistrial at all yet. You know, she's still asking for more evidence. She's still asking for more things to be submitted on both sides. Well, on the side for the defense that the state has not handed over. We found out that there was a secret ex parte meeting on June 7th, which was the day that Woody was supposed to testify when he invoked his Fifth Amendment. And the transcript is in the exhibit A, in this transcript right here. where the secret ex parte meeting transcript that has everything that Lawyer Love and Glanville talked about, and they talked about Melnick and things of that nature. And so it's amazing how we found this out. We have this information. And so at 7:15 this morning, Doug Weinstein said, hey, man, this is not fair. You know, this trial is not fair when you have ex parte meetings and things of that nature. And you have the judge being willfully biased and acting as a member of the prosecution team since the inception of this case. You know, since the beginning of this case, we find out that what our assumptions were correct. Our assumptions were correct. The assumption was that Judge Glanville was biased. That assumption was correct because come to find out, there was an ex parte meeting that showed clearly his bias, which is another reason why Brian Steele wants to question Judge Glanville. That's why he amended his witness list. He wants to question Judge Glanville. And you know what? I don't see nothing wrong with that actually, because now Glanville is a part of this case. He's a part of this case as a witness to doing some things that was very corrupt. It's the appearance of corruption. It's all kinds of things. She said, Deep says, I think she is going as far as she can before she grant a mistrial, in my opinion. That's a good point. That's very fair. She could be trying to get as much in as possible to see whether or not this mistrial should happen. So that's actually a good point, you know, and so she can't, because if she tries to grant a mistrial just based on you know, things that have happened or things of that nature, because of some bickering back and forth between the defense and the prosecution and things like that. If she has actual evidence that there is a reason for a mistrial, then and she has that evidence, she can grant that for sure. Definitely grant that for sure. So that's not a bad statement right there. That's a good point. Very good point. That she can be gathering all she can and say, you know what, this is the reason for a mistrial. You know, maybe they're a little bit late right now. Maybe she's doing that right now. Maybe she is still trying to figure everything out. You know, let's see how our likes are. What are our likes looking like, people? Make sure you hit the like button, share this video. We doing a long stream today. This is the longest stream I've ever done. And I'm a bit I'm a bit nervous about how this comes out, how this comes out, but hopefully everyone enjoys themselves on the channel. This is a small channel, new channel. So I appreciate everyone that's watching, supporting, people that's come in and out. This is the second half of the YSL motion hearing. This is the second day of the motion hearing. And so we wanted to cover this as much as possible. We're at 4 hours and 40 some minutes today. 100% of the likes. I appreciate that. Awesome. Thank you all so much. I appreciate that. You know what? We'll give you a round of applause for that. Yes, we appreciate that. Thank you. So yeah, definitely want to see how this plays out. I'm kind of leaning on what you said, D Pill. I think that she could be gathering a lot of things. I don't know. Yesterday, I kind of got mixed signals because I'm like, wait a minute. She's talking about jurors and she's talking about when the jury come back. It's like, what? You know, I'm like Bruce Harvey, like, yo, you know, it's so much muddiness going on in this case and it's so much to catch up on. There is no possible way that you can have a legit understanding of this case, you know, and it's lacking evidence at this point. And this is another reason for a mistrial too, is when the prosecution rests their case if they don't have the evidence that they stated that they were going to have in the opening statement, that's considered a mistrial as well. That's considered a mistrial as well. So in the opening statement, the actual evidence that she says is going to prove and show something, if that evidence does not come in play, if this evidence is not presented to the jury, to the court, they can ask for another mistrial and it can be granted, because the prosecution, before they rest, they have to be able to ensure that all evidence that they made in the opening statement is presented to the court. If it's not, mistrial. Abundance says she's like a roller coaster where you don't know what direction she's going to next. Exactly. And maybe she wants it that way. I'm kind of thinking maybe she wants it that way, because she kind of want to keep everybody on their toes, keep them guessing. And so it's like in 1 minute, you're like, man, she's definitely seems like she's gonna be leaning towards mistrial. Then the next minute she's talking about as we continue this case, as we continue this trial. Then she catches herself and say, well, if we continue this trial, and all these little buzzwords. That's something that I find very interesting that she does. So it's definitely roller coaster vibes for sure when it comes to this particular judge. I'm not sure what her modus operandi is when it comes to getting gathering all the information, but clearly, as we continued on just off yesterday, more evidence shows that more ex parte meetings were held and certain things that were said were very, very out of pocket, very, very unprofessional, so yeah, definitely it's very, very, it has a lot of mendacity in this case, for sure. These waters are too muddy and you can't come out the mud clean, that's for sure. They are late. This is the first time she's been late ever. The bond, I totally thought that the bond in particular for Marquavius Huey, I thought that would have been granted for him, honestly. And the reason why is because based on what he's charged with, there's no reason for something that happened before that occurred that he actually did time for, or he was on probation for, whatever the case may be, how that information now is a part, or that charge back then is now a part of this RICO charge. And that's why he's been charged, and that's why he's been arrested. And he's been in jail since, I think when we looked at Silver Fox, he's been in jail since 2022 or 2021, something of that nature. In 2022, tried to get the bond passed or granted, and they did not. That court denied bond. Okay, and so now he's trying to explain how the circumstances have changed, that we should get a bond. And I would think, the fact that the charge that he has in this RICO conspiracy, that charge being placed in this RICO conspiracy from something that happened all the way back in 2019, 2021, whatever. The fact that this is even in play towards RICO is absolutely asinine to me. I have no idea why that even occurred, but I would have thought that at least Marquavius Huey would have got bond, and she denied that. So we're like, dang, and then we had some people in the chat say, well, she denying bond because maybe she's going to do the mistrial thing, So we all have been speculating on this judge. But what other thoughts you all have about this particular judge in this particular motion hearing, how it's going so far? What do you all think about how it's going so far? It's definitely like Abundance said, roller coaster-ish for sure. Definitely. I thought I saw someone, a shadow walk by or something of that nature. Or somebody walk past. Okay, I think we got a little movement here. All right, I'm gonna go ahead. I'm gonna drop myself down, so that way, so that way when court starts, everyone can see properly, see all the way. Yeah, she's definitely killing us on the suspicion of this mistrial motion. I'm like, I legit want her to just go ahead and get this done. If we do it, look, all this happening and it's a mistrial, I'm telling you, man, it's gonna be so messed up. It'll be so messed up to go through all this and then just to have a mistrial. Having the state get all this information in, you know, this would be kind of crazy. All right, let's see. How y'all enjoying the stream so far? If you have any suggestions or any content or any type of topics you want me to discuss, go ahead and email me at taybiztv@gmail.com. Let me see if I got the email, if I can bring it up. Yeah. Content reactions. If you want to do reaction videos, want to know my thoughts about certain things, go ahead and email me at taybiztv@gmail.com. I do look at my emails all the time. Even in my personal emails, I look at all my business emails as well. And so definitely we'll be looking at this email often, pretty much on a daily basis. And so if you have any type of content or any type of thing you want me to see or react to, feel free to email me.
All right, good afternoon. Hope everybody had a good lunch.
Here we go. Thank you, Sheila.
What were we able to sort out with regard to other potential co-conspirator statements? Identifying those.
I'll be right back, y'all.
John, we have a list of potential ones.
Okay.
Sort of a broader universe. And I'd like to narrow them down before handing them over. Some of them we have reviewed and they have statements about drugs that we may not want to introduce. So there's a large volume of, for instance, calls that have certain commentary in them.
Okay. So you can identify the statements and you're saying that it may be less than the full statement and you can further narrow that, but you at least at this point have the person and their statements.
Yes.
Okay.
Up to a point, yes.
Okay. Up to what? You can go ahead and continue to explain.
So, and that's the way it is with a number of the jail calls and the calls from the wiretaps that we have reviewed.
Okay. Okay.
There are some that are left unreviewed, but the ones that we reviewed.
Okay. And for the ones that are left unreviewed, can you identify, here's the person and here's their universe of statements? We just can't tell you what portions yet? Do you understand what I'm asking?
I think I do, and I don't think we can. When you said, if you could just clarify.
Okay, so why don't you do what you can right now, and then I'll ask you the rest of it. So as to what you have prepared, let's go ahead and share that
Okay, so this is much in the way that Mr. Atkins was a list of
Right.
54 calls.
Okay.
It's similar. It contains
You don't have to count the number. You can just go ahead and give them the notice.
Okay.
Is it something that you have like a written list?
So yes, it's an internal list of notes and calls that are identified.
Okay.
So what I can do is provide to them just the calls that are identified.
Okay. So do you want to do that in writing?
Yes.
Okay. So do you want, could you at least in court identify the witnesses?
So So when you say the witnesses, you mean who we're going to be introducing through?
No, that's not what I mean. I mean, who is the alleged co-conspirator whose statement you think you're going to use? And if you have the witness you're going to use, I get it in through, that's great too. But we're looking for co-conspirator statements. So we need to know the ID of the co-conspirator.
So mainly the ones from the Garlington wiretap are the ones that are identified in the majority. That's the ones that we have the majority of. The remaining jail calls that we've identified, they are jail calls of Diamante Kendricks, Martinez Arnold, Shannon Jackson, all of whom are actual defendants who either are currently in trial or who have pled, and Marvius Nichols.
I'm sorry, I didn't, number one, I didn't hear that. Sorry, I just couldn't
Okay.
hear it. And number, my original objection just was.
Is your mic on?
My original objection was too little, too late. In other words.
I understand.
Okay.
I'm just trying to sort out what there even potentially is at this point, and then, which is harder than it should be. And then I will hear why it hasn't been shared before and why it should now be permitted regardless.
Thank you.
Thank you. So can you say those four people again louder so Mr. Harvey can hear?
Yes, Your Honor. The jail calls, the jail calls of the persons that I have in my hand that we're reviewing are jail calls of people who are currently on trial or who were on trial and entered a plea.
Okay.
So I don't think that counts for what Mr. Harvey is talking about in terms of co-conspirator statements. In other words, for instance, I have Mr. Kendricks, Mr. Stillwell, Mr. Nichols, jail calls that we had under review by the team who was working on that. And that we've identified calls from that we intended to use.
If I may respond to that, if it's Mr. Nichols' phone calls, the kid has been in jail for a couple of years, number one. Number two, those are his statements. I'm entitled to those under the discovery statute. And if they're just looking at them now, 2 years later, you should without any question at all, exclude those. I mean, this is,
Okay.
come on,
So-
10 years later.
It is my understanding that everything that my understanding based on your representation to me earlier today in court, that everything that you intend to use as a co-conspirator statement has been provided to the defense in discovery. Is that correct?
Correct.
Okay. And so what we're doing now is y'all asked that it be identified which are going to be co-conspirator statements. So it's not that you don't have it, it's that it is yet to be identified as a potential co-conspirator statement. So with regard to your objection about not having it, you have it, it sounds like. Now, if it's a statement of one of the defendants on trial right now, but it is going to be used against another one of the defendants on trial right now, it is, right?
Yes.
Then it is a co-conspirator statement. So, Mr. Nichols, Mr. Kendrick, Mr. Stillwell, you also said Mr. Arnold and Mr. Jackson. And did you say that both of those people have pled?
Mr. Arnold has pled.
Okay.
And I said Jackson, but Jackson is Stillwell, so that was
okay.
a statement.
All right, so the only person you've identified other than the three that are on trial right now is Mr. Arnold who pled.
Right, and there's also Nichols, Kendrick, Stillwell. And I have a jail call from Quindarius Zachary.
Okay.
We've identified.
That you've identified only now, not previously. So don't tell me that the three that were already identified, they don't have an issue with in terms of it. Late notice, yes. So was Zachary one of the people that had been identified in that November 2023 notice?
No.
Because the notice I have says person A, person B, so I don't know who they are.
Right, so not the jail call, the statements that he has made, but not the jail call. So the name, I believe Zachary is either A, B, or C. I have to look at our notes.
Doesn't matter who. Yes, he was identified as one of the people whose co-conspirator statements were intended to introduce, but the jail call wasn't identified within there?
That is my.
Okay. Is the jail call subsequent to the time that you provided the notice?
No, the jail call date is 2015. It's in 2015.
Okay, so is there a reason you didn't include the jail call in the notice that you provided?
When we were preparing the notice, our understanding of the need to extract jail calls that contain this information or wiretap calls that contain this information and identify them was separate from our obligations regarding generally what co-conspirators say.
Okay. Can somebody provide me either the order, oral or written, or the directive that the court gave to the state so that I can figure out whether that was a reasonable interpretation?
And we're going to get that for you. And at the time that we were under the obligation to present the co-conspirator statements, we were still, and the court was aware, we were still listening to, because there was an ongoing commentary about the jail calls and the number of them and identifying them. So we were still listening to.
Okay. So at some point, presumably you completed your listening? I mean, I know they're still ongoing, so I'm not talking about jail call somebody did last night, but.
Even all of the ones.
Do you understand? I'm sorry to interrupt you, but let me back up and ask a different question instead. Did you understand that you had a continuing obligation to notify of co-conspirator statements, even if it didn't include jail calls and wiretaps?
Yes.
Okay. And with regard to whether there was some other understanding about jail calls and wiretaps, I'll sort that out later. Let's, at this point, are there other people who you think are co-conspirators, who you think you have co-conspirator statements for that you are potentially going to want to admit in this trial? And let me direct your attention to, because this might help you a little bit. You, a couple of days ago, provided at the court's request to the court, and I assume to opposing counsel, a kind of modified list of witnesses still to go. All right. And you have at least a broad outline of evidence you expect with those witnesses. And some of these people you have actually identified specifically as co-conspirators. So, I mean, can we go through that and at least with regard to those people, see whether, yes, in fact, there is potentially such a piece of evidence? All right. So if everybody wants to follow along and pull out your state's witness list. The first one that I notice is number 3, Antonio Sledge, who you say is a co-conspirator, and then on your evidence you have listed a defendant interview and a jail call. Right. Could that potentially be?
Yes.
Okay.
Yes.
So we can add Sledge to the list. Then Zachary, you mentioned, so he's already on our list. Now, some of these I just don't know, but there are a lot of them that have interview or something like that over to the side. I mean, somebody like number 7, Kenya Morton. I don't think she's a co-conspirator, but okay. And then Arnold, who's number 27, you mentioned. How about number 35, Wooney Lee, who you have labeled as a co-conspirator?
He is.
Okay, and are there potentially co-conspirator statements from him?
So unless what we have of Wooney Lee consists of social media evidence. So arguably, if that could be considered co-conspirator statement.
Better to say yes, I think so, and it not be than the other way around at this point. I think it was 35. 33. It says 35. Oh, no, it says 35 on mine because I got what, today maybe? Or yesterday afternoon, an amended witness list that adds a few people.
And Your Honor, for the record, it added 2 custodial records for Sprint and T-Mobile.
Okay, so anyway, Wooney Lee, either number 33 or 35. How about, and you mentioned Sumlin earlier this morning, and Sumlin y'all already had notice of from November of 2023. So Sumlin's, okay.
This is crazy.
I mean, that may be it in terms of, in my review over lunch, what I noticed to be pretty obvious ones. Are there other ones?
The judge getting irritated. I think the judge is getting agitated. What y'all think? You had so much time to do this. You've had this case for 19 months, which means you had those wiretaps or those jail calls. You had them for 19 months. And you just not going to identify who is saying what and who's the co-conspirator and what? Come on, man. It's absolutely crazy. Please don't tell me we're going to sit here and wait for them to give you more names. Exactly. Just omit it. They have, and to be clear, the prosecution have until I believe like the middle of August to finish their argument. Like, what evidence have you presented? Concrete, hardcore evidence have you presented? Because after the prosecution rests their case, then the defense go ahead and do their case.
And Your Honor, I think I took it for granted, but all of the 6 co-defendants currently on trial, their statements, their social media, and the jail calls that they have, that we have of them, would be considered co-conspirators.
All right, and I'm think that with regard to the 6 co-defendants on trial, it is, I mean, pretty obvious considering that there's a RICO count as well, that the state considers those people to be co-conspirators of each other.
I mean, duh.
It still might be helpful to identify the statements, but with regard to deficiency of notice as to those people, I'm going to say that's okay, that's kind of within the context of there being a RICO count against them all. That notifies the defense that at least you think they're all co-conspirators. So if you can identify the statements as well. So that leaves, I guess, so does that mean that there are no others other than the ones we've run through just now?
I want to say that that is accurate. I want to be accurate before I say that that is accurate.
So while she's making sure she's being accurate now, somebody else can tell me, so on the notice that is from November of 2023, the 2 people who are they? Zachary and Sumlin, the people that are identified as like person A and person B? Everybody seems to know except me at this point. I mean, y'all know at this point. So how about somebody on the defense side tell me? And you don't even have to say who's who, just. Oh, okay. Mr. Weinstein, you're looking at me like, I know, but.
Looking at you like, this seems like a job for Matt Sharp.
Apparently it is, because here he comes.
I'm looking at, am I correct that you're asking about this notice of the 3?
Yeah, there's a like, I don't know what it says, witness A and witness B, or person A and person B. And then y'all said, or she said, there was a supplement that actually identified who those people were. So,
Your Honor, witness A was Mr. Copeland, and in that notice, we talk about the statements that Mr. Garlington made to Mr. Copeland. Witness B was Quindarius Zachary.
Okay. All right.
And he's talking about statements that were made by
All right.
defendant Stillwell and defendant Kendrick.
Okay.
And
yes,
I agree with 1 and 2. 3, I'm not sure has played out in actual testimony.
Okay. Do y'all know who 3 is?
So I think it says Donovan Thomas Sr. to his brother, but that was a co-conspirator.
There's only an A and a B that are like not identified people, right? Okay. Okay.
But 3 is not a co-conspirator statement, correct? Okay. So there's only 2 co-conspirators, alleged co-conspirators.
Okay. All right. So with regard then to
Damone Blaylock, Your Honor, there are statements that are made, well, there's social media that we have identified. Damone Blaylock is a defendant in this case who's been severed.
Severed, okay.
He, social media from the incident listed on the indictment that he was already tried for with one of the other defendants currently on trial.
Okay. And Lee is also a severed co-defendant, right?
Lee, yes.
Okay. How about Sledge?
Sledge is a co-defendant that already pled guilty.
Okay. All right. Yes.
You might want to know Mr. Lee, Willie Lee, he resolved this case with Lee.
Okay. But I mean, he was at one point part of this indictment, the big indictment. Okay. All right. So then really for everybody that was a part of this indictment, everybody was charged under the RICO count, right?
Yes.
Okay. So it will come as no surprise that the state thinks they are co-conspirators because the state literally alleged that in the indictment. So at this point, there is an objection that they don't have notification of what the statements are. And we are several months in. How quickly can you get to them the detail about what you think co-conspirator statements you intend to introduce? Go ahead.
Your Honor, not certain what amount of time the court is willing to allow us to identify anything not already identified or indicted. I don't know if a week exceeds what the court is willing to give. It's what we would ask to identify.
Oh my goodness.
Within the discovery already provided,
right.
Identify specific statements that are there. We would ask for a week to identify that.
All right. Understanding, Mr. Harvey, your objection to delayed notice, I am going to overrule that objection right now to the admission of the evidence. We, of course, still need to know what the actual evidence is. And a part of the basis for me overruling that is that it appears that the whole trial has kind of been operating on a like a rolling basis with regard to the evidence. And there have been orders even that, hey, you know, every other Friday, let's talk about the evidence that's coming in for the next 2 weeks. And so if that's been the understanding, then so be it. But I want that to stop right now, which is why we are going through in what I consider to be painstaking detail, because this really should not be what the court is spending its time doing. This is what y'all ought to be doing on your own. But I want us to get on a track where the litigants know what is potentially coming in against them, less than here's the universe. And I want us to be efficient, but I don't want y'all, anybody, either side, having to try the case sort of, you know, blind, or practically blind. So let's, now that I hope we all are getting a better understanding of how it ought to work moving forward, I am going to give y'all, because I've given y'all a lot of other tasks as well, 1 week until next Thursday to get all of that in detail, including anything in wiretaps, including anything in jail calls to the defense. Okay. You look like you want to say something, Mr. Steele. Okay. All right, you're welcome. Okay.
This is ridiculous.
So, what else can we get done today?
Your Honor, just to address a matter that the court asked me about before lunch. The court had asked, when I represented that my understanding, if I'm not mistaken, was that the matter of disqualification of a judge was not competent evidence to be used in the trial. I think I said something akin to that.
Yeah, and you said you had some kind of law that you could provide to us.
What I referred to was Georgia Uniform Superior Court Rule 25.6 and my understanding of it.
Okay.
If it's different than the courts, then that's not unusual. But the last 2 lines of the rules say that if a motion to recuse is sustained, the selection of another judge to hear the case shall follow the same procedure as established in Rule 25.4. Any determination of disqualification shall not be competent evidence in any other case or proceedings. So the way that I understood that, and of course that rule is, you know, cited in other cases, for instance, not for the proposition that the disqualification is not competent evidence. It's just cited in a block cite in Evans versus Williams, 341 Georgia App 226. But that's my understanding. If my understanding is not in line with what the court's understanding is, we would have other arguments against the idea that somehow the recusal of the former trial judge is competent evidence and in some way relevant to whether or not the defendants did or did not do what they are alleged to have done.
Well, it's not relevant evidence as to whether the defendants did or did not do what they're alleged to have done. It cannot in any way be evidence of that.
I mean, I was as to relevance. That was why I was saying.
All right. So relevance will be a separate issue from whether it is, and I can already anticipate the argument because I would make this argument. What you just read says any other case or proceedings. What does that mean for the case that it happens in? So I think we probably need a little bit more research.
And that is what I sought to do over the lunch hour, but I did not find any Georgia case law that elaborated on that. I didn't find any case law that elaborated on that. And so that was,
all right.
That was where I stood.
Okay. Well, thanks for letting us know what it is you were referencing, and I'm not sure if it actually answers our question or not. And it might not need to, because the relevance issue may be what answers that question, because we cannot, well, and it may be that, I don't know, I will entertain whatever y'all want to submit on that. Either competency-wise or relevance-wise, although I think I pretty fully understand the defense argument on it. But, okay, thank you. So, I know we're not quite ready on the Copeland evidence. I think we have sent out some of the transcripts we've got already. So we're not ready on Zachary yet. Are we ready on any part of Zachary? How about the part y'all had notice of?
Yeah. So, the statements.
Yeah.
I'm a little confused.
It's not even showing that I have a message, but okay. So that's a problem. Yes.
So regarding Zachary, when we're talking about the co-conspirator statements, we've been talking about Mr. Quindarius Zachary in different kind of contexts here. We've spoke of him having approximately 9 hours of statements,
right?
And we're also speaking about him in context, as I understand it, with the co-conspirator statement. One statement allegedly stated by Mr. Stillwell to Mr. Zachary, that we caught Nut down bad, and then another statement allegedly made by Mr. Kendrick to Mr. Zachary saying we caught Nut down bad. Is that correct? Those are the entire co-conspirator statements to Zachary that we're talking about right now.
Judge.
Yes.
Zachary's interviews, the entirety of those interviews and everything that he alleged that a co-conspirator told him in those interviews are statements of co-conspirators we intend to use in this trial. So he has said, and we identified that because I thought it was pretty specific as it related to the Donovan Thomas murder, what it is that two defendants currently on trial are alleged to have said.
Okay.
But within those interviews, he talks about other co-conspirators and acts, for instance, the shootings, the buying of the shootings of one of the incidents that are alleged as an overt act in this indictment. He talks about his role providing guns to members of YSL.
Okay, so the answer is no, it's not just those two.
Right, it's the whole state.
No, it's not just those two.
Right.
It's all, and so
my understanding is the state is saying, and I don't know if this is true or not, but the state is saying at this point, to the extent that they know, that Mr. Zachary's taking a stand. So that's what I understand him saying. And so him saying that he provided guns to people is not a co-conspirator statement if he's taking a stand. I'm saying what the state is saying is a co-conspirator statement involving Mr. Zachary. The only thing we've has been identified to us is those two statements, which are clearly, in my opinion, spilling the beans. I mean, we're in the same predicament as the other. That's going to be our stance, but I don't know. I can't answer the other statements that I have not been identified specifically.
The statements that the statements that Quindarius Zachary gave to the police, I'm certain everyone is aware within those statements contains statements made by other people within YSL. When he's talking about the acts that were committed, he is talking about conversations at times that he has with other members of YSL.
Okay.
He may, for instance, at one point talk about what Antonio Sledge told him to do or something of that nature. Antonio Sledge's statements to him would constitute a co-conspirator statement. So to the extent that we have given to them the interviews of Quindarius Zachary and have noticed them that he is our witness, our position is that the interviews and what is within them, it is a discrete set of information that they have noticed that we are using that.
All right, so I think I hear you saying that with regard to anybody named with at least one count against them in this indictment, which is everybody in the indictment, that anything that they say to anybody is a co-conspirator statement, potentially, because they're co-conspirators with the other co-indictees. And anything that they relay was said to them by another either indicted person or person who has admitted in judicio to being a member of this gang is also a co-conspirator statement, and that the defense is basically on notice of that anyway?
If it is contained within an interview that we have given to them,
okay,
yes. If it is a statement that is made to someone alleged to be YSL, yes. If it is a statement
not just alleged to be YSL. I mean, if you're saying they've got automatic notice of this, they need to, it needs to be more than somebody's alleged to be YSL for them to, if you're saying, hey, my notice already based on this indictment and me giving these statements over is sufficient notice.
The only reason I said alleged is that the people here have not, we're on trial. So.
Right, but they're co-indictees.
Yes.
So I was talking about people other than
What's
the
wrong with her?
co-indictees.
Yes, I see what you're saying. Yes, any statement, yes. To answer the court's question earlier, then yes. To
What is her
the extent that we
problem,
have given them that interview, yes.
All right, and so are you seeking to say, and maybe this is where Mr. Shard is asking for some clarification, that for all of those people, which is essentially everybody we talked about, that the most detail you're going to give them is you have their statements?
No.
Or are you going to break it down further within the next week?
We will break it down further, but there are only, I think, the people who've pled, and Quindarius Zachary and Kenneth Copeland, who've not.
That's a fact.
Who are not indicted, that fall up under that umbrella.
Does that answer at all your question?
Can I explain how it really doesn't, and it's kind of to move from the theoretical, the theoretical to the reality.
Yep.
The reality is these statements. For instance, Mr. Zachary gives a proffer. There's like 4 district attorneys and probably 4 investigators in the room with Mr. Zachary and his attorney. The district attorney, you're really the investigators are just peppering him. Well, tell us about the Lil Wayne bus shooting, or tell us about the shooting on, someone's house.
Mm-hmm.
And to the extent that, now I get it if Mr. Zachary's saying he was there for a certain event, but there's discussion of a lot of it. The shooting of the convenience store on Cleveland, I'm just making this up, Cleveland Avenue. And I'm just going to use my client's name because he knows I don't mean anything by this. Well, yeah, I think Shannon did that. I think Shannon did that, and that's my understanding, And there's no These aren't lawyers asking the question, and there's no indication of what he's basing it on, who told him, who he's saying told him,
Right. So
and
you
everything
need
else.
to know in
Right.
more detail,
Who
is
the
the
source
state,
is.
well, is the state planning to use, I think Shannon did that.
Right.
Is that
and-
what you want to know so that we can then drill down on, is there any basis for that coming in?
Right. I
Is
need
that
to
what
know
you mean?
what the statement is. If the state knows, now obviously if the statement says, Mr. Huey told me this, then I understand that
Yeah,
he's saying the
okay.
source is Mr.
Okay.
Huey, but there's just so much information that's just
Okay.
like being thrown out
Okay.
with no declarant, no identified declarant.
Sure, okay.
There you
So,
go.
first things first is you identify within the next week what parts of each statement you intend to use, because it may be that you are not going to use, I think Shannon did it. And so if that's the case, we won't worry about it any further. So identify them. And if you can also, before the end of the week, before a week's time is out, identify the source if it's not readily apparent, do that as well, but at least get them each statement. And so we'll go from there. Okay. All right. So what else do we need to think about? Because I mean, and I hope we can actually go through more evidence, but all of what we're doing right now is productive, even though we're not hashing out the details. We're at least winnowing, narrowing, which is good.
Right, that's gonna be a big task for
I
Adrian.
don't have
for
an
sure.
agenda anymore. My agenda got hijacked. What else can we do that's productive today? Anybody have any ideas? Mr. Steele. Okay.
I could get you brief very fast, but I argued this before the recused judge and it was denied. Former judge would not give me a certificate. I took it to the Court of Appeals of Georgia under the collateral order doctrine. I lost. And then the Supreme Court of Georgia denied cert.
Okay.
But there's a ruling on it.
Okay.
So if you don't want to rehash it.
I don't even know what you're going to ask about.
The indictment is fatally defective.
Okay.
So I could take a quick count, if you don't mind, right now, and it should apply to,
okay.
definitely applies to Mr.
All
Williams.
right. I don't know. I mean, if it is something right offhand, if it, go ahead.
Okay, well, it's a general demur. I was going to do it again at appropriate time, but since you asked.
Since you don't have anything else to do right now. Okay.
So in count 56.
You know what? Let me grab my copy of the indictment.
That mother like a
Okay,
telephone
count
book.
56.
I'll get you the page.
Give me a minute.
It's page.
Okay, got it. Page 90.
Okay, so that charges Mr. Williams. I'm just using this as an example.
Oh, okay.
Repeats charges Mr. Williams with participation in criminal street gang activity. And it gives a date range. And it says the essential elements need to be there while occupying a position of organizer, supervisor, or other position of management or leader of the criminal street gang. YSL did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity. And that lists murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle. Sorry, I apologize, Ms. Winfrey.
Street gang list.
Okay. Participation in criminal street gang activity for that said accused in the county of Fulton and state of Georgia on and between the 12th day of May 2018
and the 8th day of May 2022, while occupying a position of organizer, supervisor, or other position of management or leadership of the criminal street gang YSL, did engage in directly or indirectly or conspire to engage in any one of the following acts of criminal street gang activity of YSL, to wit, murder, aggravated assault with a deadly weapon, armed robbery, hijacking a motor vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm and possession of a weapon by a convicted felon contrary to the law, the state, good order, peace, dignity thereof. They're going to repeat, but Your Honor, my belief is that the grand jury, by and through the Fulton County District Attorney's Office, did not allege a material element. There are 4 material elements in violation of criminal street gang activity. And there's going to be a jury instruction that the court, one day is going to give to the jurors. There is a jury instruction on this crime. I'm trying to get you the pattern jury charge that gives the essential elements.
I agree with you, Sheely. Make them prove he was the leader, because they have not proven nothing yet about him being the leader of the gang. Everything in court is about proof, man. Just saying somebody did something or is doing something doesn't mean it's going to be proven. You got to still prove that in court.
Pattern jury instruction 2.02.25. And there's also case law that one of the essential elements is that the crime was committed to further the interests of the gang. That is omitted in count numbers 56 and 57 for Mr. Williams. There are other people here charged, Your Honor, that has the same issue.
Okay.
But they're different count numbers. And the way I understand the law is that the fact that the statute does not give the mens rea, every crime has to have the mens rea attached to it, and that when the legislature or Congress does not include the mens rea, the courts say that the omission from a criminal statute of any mention of criminal intent should not be read to dispense with that essential element. This rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. And here, and that was, I'm sorry, under MORISSETT versus United States. That's 342 US 246 at 252 1952. It's also explained in Elonis, ELONIS versus United States, 575 US 723 at 734. It's a 2015 case in Division 2.
I'm sorry, 575 US.
723.
Okay.
At 734. It's a 2015 case.
Okay.
It's in Division 2B. And that specifically says that the fact that the statute does not specify any required essential element, including mental state, does not mean that one does not exist. And here what happened is there was a challenge years ago under Rodriguez from this courthouse, the Georgia Supreme Court, said in order to save, or that it is a constitutional statute because it's not a denial of freedom of association, because you don't have the right to commit a crime in furtherance of the gang. That became an essential element. That changed our jury pattern instruction.
Yeah.
And our grand jury did not, in our case, did not allege that.
Okay.
So I know that there's a lot of argument about, well, this is a gang case, and then 418 kicks it, 24-4-418 kicks in. But I believe that the charges for the gang is not appropriate.
And did you say, I'm sorry, did you say that, what did you say the Court of Appeals did?
They didn't take it up.
They didn't take it up, okay.
I didn't get under Dukes, D-U-K-E-S. I don't have, Judge Glanville denied a certificate.
Oh, okay.
They never.
I thought you sought, but you did not secure a certificate. So then you took that up under the collateral order rule and.
Did not, they said it's not a collateral order. I
Okay,
needed a
all right. So they
certificate.
gave you an opinion on the merits of, is this a collateral order thing you can take up?
And
Okay,
and then they dismissed the appeal. So there's no
right,
rule of the case.
okay.
So that is, a couple of counts for Mr. Williams. He has 6. Then the conspiracy, which we're talking about. Okay, I'm sorry.
So you said that with regard to counts 56 and 57, it is not alleged.
I promise that.
Okay.
In those
And
two
are there other counts that are alleged against your client, Mr. Williams, where that is an issue?
Yes, there's an essential element in count 1.
Okay.
Which is the RICO count. And I compared it, I just did it because, it's such a well-known case, to the Donald Trump indictment out of the same grand jury courthouse. Nowhere in count 1 will you see that any of these individuals have been charged with joining the conspiracy knowingly and willfully. It is not in there. And that's RICO conspiracy count starts, I think, at page 12, but hold on.
All right. And so you're saying nowhere in, I'll read it. It's pages 1 through 68 of the indictment, but no, I'm sorry, 12 through 68. You're saying nowhere in that 50-something pages does it allege any of this was to further the interest of the gang?
No. I'm saying that it's a different.
No, that's not what you're saying, or no, it's not in there.
I'm doing a different issue in that, in count 1.
Okay.
The conspiracy.
All right.
The grand jurors charged that Mr. Williams and the others who were here, also the others who are not here, unlawfully conspired to acquire and maintain directly and indirectly an interest in and control of U.S. currency and other personal property through a pattern of racketeering activity in violation of OCGA 16-14-4A, as well as 4B, as well as B. But what happened there is, I went through it hard. There is no allegation by the grand jury that Mr. Williams or anybody knowingly and willfully joined the conspiracy. And under Cotman, which is C-O-T-M-A-N,
YSL Steel,
versus
baby.
State, which is 342 Georgia Appeal, 569, it's in Division 2.
Okay.
The 2017 case. That is a teacher from the APS trial. It was also a RICO conspiracy case. The Court of Appeals of Georgia held that in order to commit a conspiracy under the RICO statute in Georgia, it requires proof of the material element that the accused knowingly and willfully joined the RICO conspiracy. That is also in MacArthur, which is MC-ARTHUR versus Beach, which is B-E-E-C-H. Haven, which is H-A-V-E-N Baptist, B-A-P-T-I-S-T Church of Athens. Your Honor, it's 368 Georgia Appeal, 525, it's in Division 3. 890 Southeast 2D, 427, that's a 2023 case. Cotman specifically wrote that under Georgia law, a person may be found guilty of the crime of RICO conspiracy if that person knowingly and willfully joined the conspiracy, which itself contained a common plan or purpose to commit 2 or more predicate acts. There's also Wiley, which is W-Y-L-I-E versus Denton, D-E-N-T-O-N, which is 323 Georgia Appeal 161. It's in Division 1. It's a 2013 case where our second highest court wrote the material requirements needed for conspiracy under the Georgia RICO statute is for the person to knowingly and willfully join said conspiracy. There's another case called Z, like in the Honorable Lawrence Zimmerman -space, S-P-A-C-E, comma, Inc. versus Dan Tanners, D-A-N-T-A-N-N-A apostrophe S-C-N-N Center, LLC, and that's at 349. Georgia Appeal 248. It's a 2019 case. And what I used also was, I just looked at Donald Trump's indictment. I was interested in it.
Mm-hmm.
He is not only the former president, but the other alleged co-conspirators. They are charged several times with knowingly and intentionally joining this conspiracy. And it's not here for Mr. Williams. And mens rea is a material element of the crime and must be alleged in the indictment. That's in Eubanks, E-U-B-A-N-K-S versus State, which is 317 Georgia, 563. It's in Division 4. It's a 2023 case. So, you know, as you're going through this, if you're going to reconsider it, I will bring it up later, obviously, because I believe at a directed verdict motion, that would be relevant as well. But, you know, I don't know what it's like ever to be a judge. And I certainly don't know what it's like to come into a case like you're coming in. So if this helps, this is ripe under State versus Heath, H-E-A-T-H. Once the jury's sworn, a general demurrer can be made orally or in writing. I actually put this in writing.
Okay.
But I waited till the jury was sworn, and I did that, okay. I mean, intentionally, because jeopardy attached. So.
Sure. Yeah, and if it is already in writing, I'd love to have that. And I assume this got argued at one point before if the prior judge made a ruling. So if there's a written response from the state, point me to where I can find that as well. If there's not, point me to where, like what date it's argued.
I have the order, and I filed that in a motion that I gave to this honorable court.
Okay.
I'll get the motion, I attached it, but I didn't give you my brief. So if the court's permission, and of course the state has it already, but I'll resend it.
Is it filed in the case somewhere or?
Went to the Court of Appeals.
Oh, okay, that brief. Yeah, sure. I'll take it all.
Okay.
And then I'll assume the state filed some sort of a response, maybe not this team right here, but, and it may have been that more about that was about collateral order or not, but I'll take it and read it for whatever it's worth.
The state argued, and then they wrote the proposed order, which was signed by Judge Glanville. So, and it's a long order, 12 pages.
I'll take all of that.
Okay. So I thought that would be, if you grant it, it would be helpful because it would knock out all this work.
Yeah, it would. That is true.
Okay, thank you, Your Honor.
Thank you.
I'll get you that brief.
All right, appreciate it.
Your Honor, I'd also point the court's attention to the transcript dated December 11th, 2023. It was filed on that date.
Okay.
Of at least one of the hearings where we addressed Defendant Williams' general demurrer claims.
Okay. Is it a transcript from December 11th or was it filed on December 11th?
It was filed on December 11th. It was held on November 20th, 2023.
Okay, thank you.
And it was specifically as to Defendant Williams' plea and bar / motion.
Great, thank you. Appreciate that. All right. Mr. Harvey, you look like you also were maybe going to stand up and come up with something we could do. Oh, and you know what? Hang on. Sorry. If I don't do things when I think about them. Sometimes they escape my mind. So I understand that for Mr. Williams, that is count 1, count 56, and count 57 you're alleging are fatally defective. And you mentioned that may be true about other defendants as well. Are there other defendants who either have already made or intend to sometime before this goes to a jury make a similar argument with regard to counts that you have against you?
I think under the rule, we're all joined in.
Oh, right. Yes, the Harvey rule. Thank you. Okay, but if you are all joining in, can you tell me, is this essentially true about every one of the gang counts?
Yes.
That they're missing? Okay. All right. Then I can sort out for myself which ones go to which person. All right. Now, Mr. Harvey.
And this is more of an afterthought. At least I'm still having thoughts, whether they're before or after. I want to make an oral motion at this time to prohibit the state or anybody else from talking to witnesses while they're on the witness stand. Judge Glanville would give an instruction which was incorrect to witnesses. Don't talk to anybody but the parties in this case while they were on the witness stand. The only one that is, the only people that are accepted from the no talking rule once a witness is on the witness stand is a criminal defendant and the defense lawyer, because that's a Sixth Amendment impediment. The case, as I remember it, is Perry versus Leak, Perry versus Leeke. It is a United States Supreme Court case, which indicates that other than the defendant, witnesses or parties are generally prohibited from talking to witnesses once they're on the witness stand. So I would like an instruction. I can write this out. I can ask for an instruction.
That'd be great. I know you don't have to write out the motion. I mean, it's fine. I'll entertain it orally. And I mean, that's generally my understanding as well, but it's been a minute since I've practiced. It's been a minute since anybody raised that issue. Is there some kind of an exception for I mean, I know if you're on the stand and then we take a lunch break or a restroom break or something, that's one thing. Is there anything about overnight that is different?
Only for the defendant.
Okay.
And the defendant's counsel. That was the whole basis of Perry versus Leak.
Right.
The state said in Perry versus Leak, hey, you can't talk to your client while he's on the witness stand. And the Supreme Court said that yes, because there were Sixth Amendment implications, that a defendant and a defense lawyer could, but generally other witnesses could not.
Okay.
So you're
hazy
close.
Memory.
Yeah.
All right. Does the state have a response?
Your Honor, I believe that the rule that Mr. Harvey is referring to essentially is the rule of sequestration, and as it relates to other witnesses and about talking about the witness on the stand's testimony. The reason I was looking feverishly is that Ms. Hilton and I had actually discussed this, and I had sent her a case, not from within Georgia, but it literally spoke directly to it. So I was at least looking for that. Because I don't think that under the rule of sequestration that attorneys, I think that Judge Glanville had it right, attorneys are not prohibited from speaking to witnesses, but I want to make sure that we get the law.
Let's make sure we get it right. So I'll submit whatever you want to submit on that as well. All right. Thank you all. We're gonna take a recess right now if there's not anything we can do immediately. And we will be back at 3 on a Rule 22 matter. Y'all got that notice, right? That there was a new Rule 22 filed?
Yes, sir.
Okay. All right.
All right. So they even got the indictments wrong. Oh man. This is crazy. So definitely this has been a long day for me. I'm going to go ahead and cut it right now. I've been going for about almost 6 hours now. So I'm going to go ahead and leave it be. I know the lead attorney is also streaming this right now. And but I'm going to go ahead and stop it. I'm getting a little bit tired, guys. I apologize. I have a little bit more energy maybe tomorrow or Friday. But yeah, definitely this is very, very interesting how they even got the indictment on the RICO incorrect. You know, like the indictment is you know, when you do if you have a RICO charge, you have to knowingly know that you're in a conspiracy, right? And so the fact that they didn't even place that in the indictment is mind-boggling. You are so welcome, Sheely. I appreciate you. I appreciate you, Abundance. I appreciate you as well. Thank you all so much for hanging with your boy for 6 hours. We did it for 6 hours. Okay, let's go. 6 hours. Yeah. Thank you so much. I hope I'm going to try to feel better as much as I can. Again, I'm a little bit under, and I could tell in my voice and everything like that where it's a little scratchy and stuff, and so I'm not really feeling that great. But I tried to do as much as I could for you all, and I appreciate you all for watching. Cat Not Williams is also is streaming this as well, and the lead attorney, so you can head over to them, or you want to continue to watch Law and Crime yourself. It's all up to you. But thank you all so much and for watching the stream, and I will check you guys later. And I hope you all have a great day. All right, y'all take care. Bye bye.